I do see a record button on my screen. I did see a record button, so theoretically I could be doing that, right? In webinars.
Yes.
But the key thing was to go on my notes was to say that we're going on the cloud. I do see a record button on my screen. I did see a record button, so theoretically I could be doing that. Oh, now I can hear myself. Oh my God.
Mhm.
All right. Okay, so all right, let's go. Let's start out with my script here. Okay, as chair of the House Commerce and Consumer Affairs Committee, I find that due to the state of emergency declared by the governor as a result of the COVID-19 pandemic, in accordance with the House Rule 67 and the governor's emergency order number 12, pursuant to Executive Order 2020-04, this public body is authorized to meet electronically. This is a public hearing on bills referred to the committee and scheduled in the House calendar for today. An executive session may be held on any bills referred to this committee. However, this chair does not exact anything on the same day. Please note that there is no physical location for members of the public to observe and listen contemporaneously to this meeting. However, in accordance with the emergency order, I am confirming that all members of the committee and the select legislative staff have the ability to communicate contemporaneously during this meeting through the Zoom electronic meeting platform, and the public has access to contemporaneously listen, and if necessary, participate in the meeting by the Zoom platform or by telephone. All necessary access information has been made available in the House calendar and through the electronic calendar on the General Court website. The notice of this meeting complies with House rules and RSA 91A. Anyone who has a problem accessing this meeting shall call 271-3600 or email hcs@ledge.state.nh.us. In the event the public is unable to access this meeting, the meeting will have to adjourn and be rescheduled. Please note that all votes that are taken during the meeting shall be done by roll call vote, and your face must be present on the screen. Let's start the meeting by taking a roll call attendance, with each member stating their presence. Please also state whether there's anyone in the room with you during the meeting, which is required on the right to know law. So, Mr. Clerk, would you go ahead with the roll call?
Okay, roll call. Representative John Hunt,
Yes.
Representative John, you're going to have to help me with your last name. I apologize. Petusik. Representative John Petusik.
You're supposed to say you're here, John.
So
John?
we'll imply that here means no one's in the room with you. Representative Jason Osborne. Representative Keith Ammon, clerk present. No one's in the room. Representative Max Abramson.
Here.
Representative Bonnie Ham.
Here, and no one's in the room.
Representative Joseph DePalma.
Here and alone.
Representative Jeffrey Greason.
Present, and I am by myself.
Representative Dawn Johnson.
Here and in the room with Representative
Petusik.
Okay. Representative Paul Terry.
President, and I'm here in solitary.
Representative Christy Bartlett.
Here, and I am in the room alone.
Representative Richard Abel.
Here and I'm at home by myself.
Representative Chris Hurwitz.
Present, and I'm alone.
Representative Connie Van Houten.
Van Houten, I'm here alone, and I'm present.
Van Houten, present. Representative Tina Fargo.
I'm present, and I'm here alone.
Representative Joyce Weston.
I'm here and I'm by myself.
Representative Jane Bellew.
I'm here at home, and my friend Jack is in the house with me.
Representative Anita Burrows.
I'm here alone downstairs, but my husband's in the house.
Representative Chris McClear.
Chris McAleer. I'm here. My wife is in the house, but she is leaving.
McAleer. I will do my best to get everyone's names correct. Please forgive me a few times, and I'll eventually get it. That's the
Right.
role, Mr.
All
Chair.
right, thank you very much. And yeah, I forgot to mention I am alone. Okay. I don't know if there's anything else I need to do. So why don't we just get going? So we'll open up the public hearing on House Bill 610. And even though I am the prime sponsor, I am presenting this bill is in request to the banking department. So I will have the banking department testify. So that means I have to go over to my attendees. And I guess, Kiara, you're the first one to speak. So do you mind just raising your hand, Kiara? That way I see, now I see you. Okay. And so I'm going to click on, well, I was allowed to talk. I want to have you allowed to speak, to see you. All right, I'm promoting you to a panelist now. So you're now a panelist, Kiara. And are you on? Did I?
Yes, she's here.
Okay. So you might be muted, Kira. Yeah, I don't see a picture.
There we go.
Okay.
Sorry, I've now
Great.
unmuted. I'm sorry, I don't have a picture because my internet connectivity doesn't seem to like me when I put on my audio and video. So I'm sorry, I'll just be speaking today and you won't get to see me.
Okay, thanks.
So thank you so much for allowing me to testify on House Bill 610. We at the department call this our fiscal efficiency bill. The changes are requested. We're hoping to improve the regulation of trust companies, eliminate waste and inefficiencies, reduce costs associated with various regulatory processes, and more equitably allocate those costs. There are a number of changes in the bill, and if you look at the bill itself, there's an analysis section at the very top that sort of lays out a description of the changes that are requested. And so what I've done in the written testimony I provided to you is I first placed each of those Roman numerals from the bill analysis in the table, and then I added some bullet points to provide some further explanation. So I've done this in the order of the bill sections, and I've referenced the bill sections. I'm hoping that helps you follow along. So first, we're requesting a change to require all of our licensees to license and file reports through the NMLS system. This is a system, electronic system that we currently have all of our mortgage industry licensees using, but we maintain a dual licensing system for folks who don't license through NMLS. What we're asking for is to require all licensees to use the NMLS system. That'll eliminate the dual systems that we currently have to maintain and operate. We're going to be asking for this change for currently retail sellers, sales finance companies, small loan lenders, debt adjusters, and money transmitters. Last session, we asked for these changes for the money transmitters, but that bill, HB 1437, got caught up in the omnibus bills that were vetoed, so it unfortunately didn't pass. So those are bill sections 1 through 15 to make all those changes happen. Next, in sections 16 through 19, we're asking again to have the provisions that were put forward last session in HB 1695 incorporated into law. 1695 from last session was a result of the Senate Bill 98 study committee addressing trust companies. So these requirements would add a requirement in law that would have new trust directors submit to a background check. It would give the commissioner authority to remove directors or officers of trust companies and family trust companies if needed. I would note that the analysis references that the provisions would be applicable to both applicable for the background check to trust officers. It should actually read to trust directors, but the removal provisions apply to both directors and officers. So just the analysis section, that Roman numeral description was a little off. Just wanted to make that point, but the bill itself is correct. And then section 20, again, is another provision that was put forward in last session. That was HB 1696, again, as a result of the Senate Bill 98 study committee. This proposal would increase the fee for filing an application to charter a new trust company, bank, or credit union. It increases that fee from $10,000 to $15,000, and also authorizes the commissioner to charge additional fees, costs for reviewing more complicated applications. We did have one change from last session's language in 1696, which was made at the request of industry representatives, just to clarify the process by which we notify them that additional charges may be incurred. Section 21 addresses assessments. We on occasion have entities that are chartered in New Hampshire, and they either close their doors, they dissolve, or they convert from state charter to federal charter. Currently, we have the authority to assess those institutions, but sometimes the transition from state charter to federal charter or their dissolution happens before we've had a chance to actually issue the invoice for the assessment. So we're just trying to clarify the law to give some additional requirements that will allow the commissioner to work with those companies to collect that assessment. And then finally, in section 22, or sorry, not finally, we've got a few more. In section 22, we're asking to have the interest rates that are used for payment of interest on escrow accounts that pay the taxes and insurance on mortgages. We're asking to have that interest rate tied to the federal funds interest rate. Currently, we calculate that interest rate, and we have to ask twice a year, ask the depository banks to submit information to allow us to develop that rate. By tying it to federal funds interest rates, we don't have to do that calculation, and the banks can go directly to that federal funds website, open market committee website, and get that interest rate themselves. And then finally, sections 23 through 28. This is a provision that was again put forward last session. That was an HB 1437. That bill was also caught up in the omnibus bills and vetoed, but the provisions would allow us to transmit consumer complaints via email rather than through snail mail, certified post office mail. We really have, especially with COVID, had a difficult time managing to mail out these letters with post office issues. They don't get delivered. And sometimes it takes weeks and weeks for us to get a complaint to a licensee. So we would like the ability to send them by email, which is much more efficient, allows us to ensure that the entity has received that email same day with the ability for using received options in Outlook that we have. So we're asking for these changes to be put in place, and this would affect all of our both licensed and chartered institutions. So those are all the changes that we're requesting, and I'm happy to answer any questions. And I have with me other folks from the department who are much more knowledgeable about these provisions and can answer more specific questions that I can't.
Okay, well, we have one raised hand. Representative Terry, you got to first unmute yourself. There you go.
First, a question for you, Mr. Chair. I requested a packet of bills that were going to be considered today be mailed to me. And the packet was mailed on the 22nd, and I'm not seeing bill number 610 in the packet.
Really?
So I'm at a distinct disadvantage here, being able to participate with respect to the discussion and consideration of this bill. Wondering how I can access that. And then second, Mr. Chairman, if I may ask a question of Ms. Dolcino once you respond to me.
Okay, so yeah, so if I assume you only have one computer, but you do need to pull up, if you pull up your search engine and go into the House of Representatives. And in House of Representatives, there are several ways to go find bills. I usually go to the committee and then say bills that are in the committee. But right on that front screen, it'll say ask you for a bill number. So if you type in HB 610, it should pop right up for you.
Okay, I'll get up my other computer here and
even better.
I'll be ambidextrous.
Okay, I will. Well, I'll leave your hand up, knowing full well that you have a question. Or do you want to ask that question now?
I'd like, yeah, may I ask that question?
Certainly,
if I may. And I'm sorry, Ms. Dolcino, I am unable to specify exactly when and where you referenced a proposed fee increase from $10,000 to $15,000.
Yes, that was a provision that was put forward last year. It affects trust companies, banks, and credit unions that are seeking to be chartered in New Hampshire. Those changes were worked out as a result of the Senate Bill 98 Study Committee. And currently the fee is $10,000 to charter a new bank, credit union, or trust company. And that is increasing from $10,000 to $15,000.
So if I may,
Further question, you may inquire.
so if I may, thank you. Thank you, sir. What apparently the fate of the request last year died or was rejected. If you could speak to the history of that from the last session, I would appreciate it as a new member. And second,
Yes.
with respect, and second, if I may, with respect to the increase, since we're talking about a state function, how does the current and how does the proposed fee compare to other states for the same service?
Right. I honestly don't know what the other states charge, but perhaps giving you a little more information about how the banking department works and how we're funded might be helpful. The banking department is not general funded in that at the end of each year, we use a calculation to determine if the fees we've collected cover all of the operating costs of the department. If they don't, we impose an assessment, and then all of our chartered institutions kick in and pay that assessment. So by increasing the fee, what we're hoping to do is capture the actual work involved in reviewing those trust and bank, et cetera, applications that are filed. If we don't capture the cost of reviewing the application from the applicant, then the rest of the institutions foot the bill and pay more in the assessment. So it's really more of a cost shifting from what we're trying to accomplish is have the institution filing the application pay the cost for us reviewing that application, as opposed to pushing the cost onto the assessment and the other institutions. I can look and find out what the other states may charge for similar applications, if that would be helpful. I don't have that information right now.
Mr. Chairman, one last follow-up.
Yes.
Thank you, Ms. Dolcino. Would you do so, please, with respect to your offer to look at other states and what they charge for a comparable service? And given time and perhaps staffing issues, I would be satisfied if you would do so for New York and the New England states. I don't see any reason personally for me to have you do a 50-state survey, but regionally, New York and the New England states, I would appreciate that if you get that to me. Thank you. Thank you,
Will
Mr.
do.
Chairman.
Okay, if you're all set, and just drop your hand, or I guess I can I drop you low? I'm lowering your hand. Okay, Representative Bartlett.
Thank you. I just wanted to point out that last night when I went through all the bills, there were a few missing. So going to the website of the General Court and making sure your bills are there and just print out what might be missing would help us all when we're ready for committee day.
Anything else? All right, I'm going to drop your hand. Okay, and Representative Abel, you are muted.
Thank you. There's a category of large family trusts, some that are foreign, or I should say alien, being outside the United States. I wonder if this affects them, or are they exempted from any of the changes here?
They are not exempt from the changes that would affect trust companies. Let me just go through it methodically. The background check would apply to them for the new directors. The assessment would apply to them where we're seeking to collect the assessment if they were to dissolve. And the complaint provisions, I think, would apply to them as well. So yes, it applies consistently to any of our chartered institutions, family or non-family trust companies. And if that's, I'll go back and double check that. If that's incorrect, I'll certainly let you know, but I do believe it applies to those folks.
Okay, anybody else have any questions? I would be remiss if I didn't point out that I did have a phone call from the Auto Dealers Association, and they're a little concerned about the notification because they're used to getting the notification by certified mail, and they're worried about being sent an email and having it end up in their junk box. But I would hope that because they're in the sales business, they don't have too much there in their junk, that they're always like me. I never know when a constituent sends me a letter, sends me an email. I have to, so I did away with my junk. Sorry. It just because I've got to be able to see everything. So could you respond to that concern about how we make sure that dealers or anybody, if we're sending it to them by email, that they will make sure they actually get it in a timely fashion?
Yes. So first of all, when you become licensed through the department, you're required to provide us with contact information so that we can get in touch. We often need to reach out to a licensee. Obviously, if there's a consumer complaint, if we need to discuss with them some concern we may have, setting up examinations, et cetera. So as part of the licensing process, they're required to give us contact information. And they're also required by law to update that information at any time. So if their contact information changes, they need to give us that. We have not had any issues with reaching folks by email. We have had issues reaching folks by certified mail through the post office. We've had those certified mailings come back. With email, it's much easier to find that, to confirm that someone's received the email. So we have not had the issue with the email. I understand that there are concerns. There are a whole host of ways to address those on the licensee's end. First of all, of course, to keep the contact information updated. But in addition, if they add the banking department to their contacts, then we won't get stuck in the spam. And there are other things that they can do. They can create a consistent email address that multiple people access. Just in case someone's on vacation, then other people will be checking the email. There's a whole host of wonderful technological solutions to these issues. And we're certainly willing to work with our licensees. If we send an email and we don't hear back, we are always reaching back out and trying to contact them. So I don't think in real terms, this is going to be an issue for them.
Okay. Representative Abel, you have your hand back up again.
Oh, I'm sorry.
Okay. Is there anyone else that has any other questions?
Representative.
I don't even see you on my. Okay, did you raise your hand? Oh, that's right, because I can't see you raise your hand because you're in the committee room, right? And I can't see 610. Okay, Representative Johnson, do you have a question?
Yes, I do.
Go ahead.
My question is, the beginning, you were talking about it being for finance, loans, debitors and stuff and so forth. But what do you mean, and can you clarify retail sellers? Because when I think of a retail seller, that is, a clothing store. This is insurance. Right, so I just.
Thank you. Yeah.
Sorry, this is the clerk. I'm not able to understand what was just said.
So Representative Johnson is asking, what is a retail seller? Is that correct, Representative Johnson?
Right, because when and anybody else is labeling it.
Right. So what is the definition of retail seller when we come to the banking statute? Yeah. Okay. Representative.
Sure.
Attorney Delcino? Yes.
Yes. So the retail sellers are the folks that basically are the car dealerships that are helping to arrange the financing using a retail installment contract. They help the consumer. They, they're with the consumer when the consumer buys the car, helps them fill out the loan application, and then ultimately that loan is transferred to the lender. So that is your retail seller.
Okay, thank you for that. I appreciate it.
Okay, so just so let's make sure we all understand this. So when I was in the computer retail business, we used to help people get GE financing to buy a computer. in the retail business. Do I have to register with the banking department?
No, the retail sellers that we're talking about are the folks that are just selling cars. We don't regulate other folks that help arrange financing for buying sofas or other things like that. We're just talking about your car dealerships.
So statutorily, it was just narrowed to only car dealers who have to pay this $50 a year registration fee.
Those are the folks that have to license through the department, and we regulate them because they're working with the consumers on the financing applications, and so the law requires those folks to be licensed with us.
Okay, great. Are there any other questions? So I guess I'll have to pay attention to that 610 square. But I don't know how I'll have to figure out to do that.
Chairperson
Yes.
Hunt,
Yes.
Representative McCallum has had his hand up for quite a while.
Really? I don't see it on my screen here, but go ahead.
A question, Ms. Delchino. How do you define a family trust? What exactly, how far down the line does that go?
So a family trust company is a specific type of trust company that I'm going to pull up the law right now, just so I'm not going to misspeak, and I can give you the actual definition. But these are trust companies that are formed by a family in order to manage the wealth of that family. So let me see here. Hang on just a second. I'm going to give you the official statutory definition, which I'm sure is going to be incredibly clear to everyone.
Yeah, it give you a little side story, Representative. So this is actually one of our newest of our different kind of trust legislation. Many years ago, I sponsored the original trust statute, and so that would bring us competitively to other states in terms of how we have our bank and trust law set up. Over the years, different things have created, and these new family trusts are a new item. We created a study committee because we wanted to make sure that how we were regulating them and how we were feeing their fees is done correctly. And some of this legislation is actually driven by that study committee. But you can go ahead now, Attorney Delcino.
So unfortunately, the definition is not helpful at all. A family trust company is a trust company that is organized under the laws of this state and authorized to engage in trust business under 383-D. So that's really probably doesn't provide any elucidation, but in layperson's terms, and I consider myself a layperson in this regard, it's a trust company that's formed to help a family manage its wealth. They only interact with family members. They don't interact with the public. And you have to be related by a certain number of degrees to the family member that creates the trust company. Generally, these family trust companies are really only practical for folks with very significant wealth. You're not going to be setting up a family trust company, unless you win the lottery or have a whole lot of money. Let's put it that way.
And then, this was somewhat controversial because it wasn't that they're necessarily going to be New Hampshire citizens, that we were going to draw, but to draw more wealth to the state of New Hampshire, that we could be taxable and interest income. So this, they brought up a lot of different issues around this particular subject, the family trust. So we certainly can spend a little more time in helping you get your arms around it. But yes, go ahead. Further question.
So in other words, if I'm the trustee of my mother's trust and I'm just dispersing the assets, this has nothing to do with that.
Nothing to do with that.
Absolutely nothing.
Nothing to do with that. That is correct. Glad you asked that question. All right. Okay, now I'm looking for more hands up. I don't see any other hands up unless anybody knows something. Let me help you out. Otherwise, I will. Well, before I close the hearing, I'll read the blue sheet, which is people who have signed up either for or against the bill and have duly noted. So I have Todd Wells, who's from the banking department in support. I have Nancy Daigle from the banking department also. And I see they don't take positions. So excuse me, no positions. testifying. No, that's position of support, but not testifying. Okay, I got to get used to the screen. Okay, and then Raleen Shute. So all these people are all online visiting us from the banking department. They also support the bill. Amelia Godardi is also from the banking department in support of the bill. And of course, we have the commissioner, Jerry Little, is online and supports. We have John Daly, who's a member of the public who's opposed to the bill, but did not ask to be speaking. Tom Parasol, who is the Mortgage Bankers and Brokers Association in New Hampshire, who are regulated by this, supports the bill. We have Dave Collins, who's also a lobbyist, who represents New Hampshire credit unions, and they're in support of the bill. We have Glenn Perlow. He's a lobbyist, and he does a lot of the family trust business, and he's in New Hampshire Trust Council, and he's in support of the bill. And then finally, Ryan Hale from the New Hampshire Bankers Association, who's in support of the bill. And having nobody else, I will close the public hearing on House Bill 610. Okay, no gavel, but sound like somebody did that. Did you do that for me, John? Did you hit that gavel? Okay, so what time is our next bill? What did I do? Yeah, okay.
Next bill is at 9:30, so you're right on time. It's perfect.
Right on time. Okay. Okay, and look at that. Something, the HB 312. So our tech that's in the committee room is on Johnny on the spot also. So I don't have to tell everybody. All right, we'll open up.
Oh, that's me, by the way, just so you know.
Oh, that's you who's doing that. Oh, cool,
That's
cool.
me.
Because that's a new feature. I didn't know that was coming. But
That's our substitute for it allows everybody to see what bill we're on, if they should come into
Right.
the meeting and wonder if you're running late or,
Right.
that's,
Because I thought I had sort of be like the radio talk show to keep telling people what station we're on. So,
Right.
but anyway, it's great. So you're doing it for me. All right. So we'll open up the House Bill 312, and which is the other banking department bill, and we'll hear from Chiara Delsino again, who will present the bill for us.
Thank you. So the written testimony I provided you follows the same format as the prior bill, HB 610. I've pasted from the bill analysis the Roman numerals that are found there, and then provided some further clarification and identified the bill sections affected. So HB 312 is what we would call our clarifications bill. It applies to both, the provisions herein apply to both chartered and licensed entities. And we're making adjustments that we feel will help clarify existing statutes, make them less confusing, help formalize longstanding interpretation of our laws, or will eliminate provisions that are obsolete or unnecessary. So to go through each of the sections, the first part of the bill, sections 1 through 5, and then section 13 at the end, are amendments that will help further clarify the deadlines that apply to examinations of our consumer credit licensees. Currently, the law as written is not that clear, so we've proposed amendments to make the deadlines for those folks to submit documents and information to us more clear, and to give them a slightly longer period of time to provide that information. We're also asking for a slight change to Chapter 399G, which applies to money transmitters, so that the provisions related to production of documents and examinations mirror the other consumer credit chapters. For some reason, the provisions were sort of out of sequence. In section 6, we're asking for a change that's been necessitated by COVID. With COVID, we have mortgage loan originators who are now teleworking from their personal residence. Current law may seem to require them to be licensed in their state of residence, even if they're not working with consumers in that state. So we want to amend the law so that they're not required to be licensed in their home state if they're working from home. Section 7 applies to family trust companies. Currently, we examine all chartered institutions, family trust companies, banks, credit unions, etc. We have specific provisions that state the commissioner can examine entities more frequently than every 36 months or whatever the applicable time frame is. We are asking to have the same language added for the family trust company examinations. We think it was just an oversight that they weren't in there. And so this will bring those folks in line with the other chartered institutions. Next, in sections 8 through 10, we're asking for clarification that depository banks can elect to operate as a benefit corporation under 293C. We have currently 2 banks that have elected that status, and we just want to incorporate clear language in the statute to authorize that. In section 11, we're asking for clarifications to the provisions that apply to credit unions and the delegation by credit union boards to committees. We just want to clarify that the credit union board still has an obligation to oversee the work of the committee and review minutes. These provisions that we're seeking are identical to the ones that already exist in laws applicable to banks. And then finally, in section 12, this is a change that we requested back in the 2020 session in HB 1437, and they adjust the restrictions that apply to just the commissioner and deputy commissioner as to the types of loans and other financial transactions that they can engage in. We want to modernize our existing law so it conforms to, the state ethics code that's now in place. Essentially, it would allow our commissioner, deputy commissioner to finance a loan to purchase a vehicle, a mortgage on their home, etc., as long as those mortgages and those other financial transactions are all consistent with the ethics requirements and are done in the normal course of business. So those are all the provisions in this bill, HB 312, and I'm happy to answer any questions.
Okay. So if you want to ask a question, please raise your hand. Oh, Chrissy was there, but not. Okay. Representative Van Houten. Do I have to unmute?
I'm all set. Thank you very much. And thank you, Attorney Dolcino. I have just a couple of quick questions. One is just a grammatical question, I guess. I'm looking at Roman 4, 2B. That's on page 2 of the document that I have. It begins failure to provide files and documents. And it appears that there's been an effort throughout this to change that to and or.
Right. The request that goes out to the licensee sometimes asks for them to provide actual documents. Sometimes it asks them to provide consumer loan files and other similar files. Those are terms of art with our examiners and with our licensees. So we wanted to try to make it clear that it's or, not and, for those types of documents or files.
Follow up, please.
Further question, may inquire.
So I'm assuming that and should be changed to or based upon what you've just said. Am I correct?
Yes, and I thought we did attempt to make those changes in all the sections affected.
Thank you. Follow up, please.
Yes, further question.
In the last section on bank commissioner qualifications, I know we've had legislation that talked about this in the past, but I still would just like to mention my concerns about the qualification that includes fails to become a resident of the state within 1 year after his or her appointment. I still see that as something that's very difficult to follow up on and to make sure that we have ascertained that after a commissioner is named. So that's just a comment about something that I'm uncomfortable with, that I've always been uncomfortable with. Thank you.
I would say in my 30-some years, bank commissioner has always been a resident, so I guess this issue has never come up, but fair enough. You can I'll put your hand down for you. Okay, is there anybody else? Okay, Max, Representative Abramson has a question.
Can you folks hear me?
Yes, we can.
How would this bill, if passed, affect individuals who have, say, a business or a home in a family trust? Are they going to be affected by this?
The only provision that would really affect the family trust company is the provision where we're asking to allow the commissioner to examine more frequently than every 36 months if if it's deemed necessary. In current law, the commissioner can open an investigation and conduct what we call a visitation at any time. So in practical terms, the commissioner does have authority to step in if something arises that causes concern and conduct essentially the equivalent of an examination of that family trust company. So that would be the only provision in here that would directly affect a family trust company. And again, we think that under current law, essentially the same process could occur.
Yeah, I think I know where you're going with this, Max. So I'm going as a trust fund baby myself. The word trust fund is probably a misnomer here. Yes, these are called trusts, but they're nothing to do with your trust funds that those of us who are fortunate to have. They're not affected by this legislation whatsoever. Is that where your question's going?
Oh, my question is not going anywhere. It's an open question.
Oh, okay. So do you feel satisfied, or do you have another question or follow-up?
No, that's fine.
Okay, great. All right. Is there anybody else? Looking for hands. So I don't know. The hands are supposed to pop to the top, but I don't know how I missed. Okay. Seeing no other questions. And before I close the hearing, I will then read from the blue sheet, and we do have a couple of more people from the banking department. Raylene is in support of the bill from the banking department, and Nancy Daigle also from the banking department is in support of the bill. And with that, if there's nobody else wants to speak, we will close the public hearing on House Bill 312. Okay, so now I'm ahead of schedule, but
Chair, I just, Mr. Chair.
yes,
I just
Representative
wondered
Bott.
if everybody understood how to raise their hand.
Yeah, does everybody
Does everybody understand how to do that? There's a taskbar on the bottom.
Okay,
At
so
least
Connie
there's on
Connie was testing us. Yes, she put her hand up again. Yes, yes,
Question.
yes,
Okay, so Connie knows how to do it.
yes, yeah, yes. Representative Van Hout.
Thank you. I just want to ask, I guess, a point of order question.
Yeah.
How do we go about submitting amendments now that we do not have access?
Fair question. Okay, so I would ask, certainly this bill, well, the first one we did and the next one we're about to do are our two early bills. So those ones we want to get out of the committee in a timely fashion. I have actually scheduled every bill already on a per day basis, but that until they give me or give us a second day rather than just Tuesdays, because if we only met on Tuesdays, we would not be able to make our deadlines. So we actually do need another day of the week. And I'm told that there is a possibility we won't get it for next week, but we could get it the following week. So in any case, what I did was in scheduling bills is I put in an exec session at 1:15. So after lunch, we would exec, and it's really 15 or 30 minutes. I'll be frank with everyone. If we get too deep into needing to amend a bill or process of a bill, then I will be urging everybody to just retain the bill, and we'll take that up in September to really do our, what this committee is known for, which is get it down and dirty in subcommittee. Having said that, I would urge anyone who, in terms of any bills we heard, if there is issues that you care about or want to work on, I would urge you to contact me to let me know that you have an amendment for it, or you would like to do an amendment, or you want to talk about it. So at that point, I can then plan in terms of scheduling how we want to handle that concern. And like I say, if it's, let's say if you just want to remove the residency requirement, okay, that's a pretty straightforward amendment. We could take that up at the time we are executing the bill, because that's pretty straightforward, simple, concept. If we get into a big long discussion and it's clearly the committee is really torn on it, then I'll just say, okay, well, let's just retain the bill then and work on it next year. So I would hope that if there are little minor tweaks that we can fix the bill with, and again, it's make me aware of it, that you're concerned, then I'll just have to make sure I schedule time and figure out how, how we can accomplish that. Does that make sense? Yes, go ahead.
Follow-up, please.
Yes.
No, thank you for that. And I think there's that one little glitch of and should be or for one thing. And I am considering that residency requirement and just wondering about that. However, what would be the procedure that I would have to go through? Just to inform you, I don't have to go through OLS and get a drafted amendment to bring forward?
Well, I mean, informing me would mean we have a conversation and I'll try to talk you out of it, or I'll try to make sure I understand what your issue is. At that point, if it does seem appropriate to have an amendment drawn up, then you and I would discuss it. And we would then tell Pam, who just made herself visual, that we would have that amendment drawn up so that we would take it up when we're executing the bill. So did you want to comment, Pam?
Yeah, I thought I would just add in the process that was actually established last year, or maybe even the year before, where ask OLS at leg.state.nh.us is the process that they started using, before the pandemic, for submitting information about, amendment requests and mailing them back to you, emailing them back to you. And so we had stopped the paper pickup process.
Right.
And so that will continue. Ask OLS at leg.state.nh.us works. Notifying, asking me to help out, absolutely. And conversations with the chair so he knows what's going on, all
Yeah.
makes sense.
Yeah. So I've been saying, Connie, that if, obviously I'll, generate an opinion one way or the other about the amendment, but that the process now is that we would then go through OLS and they would then email the amendment to all the members, and then we can figure out how we want to dovetail it into the bill or not.
Okay, maybe we can talk offline about those two little glitchy things. Thank you for the input. And Pam, thank you as well.
Okay. Yeah, 'cause I thought the and or they got it on all, but you're saying there was one of them they didn't get? That there was one and?
Right, it's on, I'm looking
Yeah,
at
on page 2, line 15.
Yeah, see, I don't have those sheets. I had to print mine out. Okay, but I know I see failure to provide. There's the one and deleted.
It's the new B in the middle of my page.
Yeah.
Said the first words are failure to provide files and documents.
Oh, see, on mine, the and is crossed out.
Really?
And I printed mine offline. I mean, from what's online. But on mine, I'm looking. So after 2, which is delivered to Commissioner files, B, failure to provide files, and is crossed out and says or documents within time established by this paragraph shall subject a licensee or person to a fine of $50 per day for each day. And
what's under Roman 4?
I think that's the line above.
Roman 4 is all crossed out. Okay, so now going down Roman 4, and you're saying in the B of Roman 4.
2B.
2B, failure to provide files and documents within the time established by this shall subject a person to a fine of $50 per day. After 20 of each day, the files or documents are not produced. So after you get the after 21 days is deleted, right?
Well, but you have at the very beginning of B, failure to provide files
and document. Okay, I got you. Okay, so yes, so we'll have that amendment that amendment drawn up.
So Pam will take care of that already?
Yes, Pam now knows about it, so she will make sure she'll take care of it. Right, Pam?
Right. Just changing that one and to an or.
Yeah. Sorry, I was looking at the wrong place.
Sure.
So that's the downside of not having the bills as printed from the. Okay.
And I would just add, Mr. Chairman, that one reason is that not all the bills were sent out was that not all of them have come back from the print shop yet.
Okay.
So the scheduling happened faster than the printing in some cases, and that's unfortunate.
Right. Well, I found myself I couldn't begin to scheduling bills until I had printed out, and as you remember, Pam, in the old days, I used to have to lay them all out and figure out where I would do to match them up. So, okay, Representative Immonen has a question. Yes, please.
Yeah, I just have a technical question. This is my first time on the committee, my first time clerking.
Yes.
And so what I'm finding is there are terms that I'm not familiar with, and it takes me a little while to process it so I can think about what I'm supposed to type.
Okay.
Is there a way we could slow things down a little bit? What do I do if I fall behind and I need to catch up?
You just have to, you can just say, Mr. Chair, please pause for a second.
Okay.
I would say that that most of our bills won't have these kind of technical language, and when we do the department bills, and I guess we do have the insurance department, so they might get into the same problem. You know, but I will urge them to try to be, and then when we get to the insurance bills to the department, I'll tell them to try to make sure that you slow down with new concepts that members of the committee might not be familiar with.
Right, just to explain, you know, what an acronym might mean or what a certain term might mean.
Good.
That would be helpful. And then you press record on this. That's going to be available later.
So yeah, so for everybody, just so you know, all these sessions are available right now, even as we speak. So if someone else is not in the room, they can go on to YouTube and watch the streaming on the House of Representatives webpage, YouTube page, and just go to Commerce, and it should be there. And of course, you can then restream it anytime when as a clerk to see what was said. So you can do that again also. Yeah.
Great. Can't wait to listen to the whole thing all over again.
Yeah. Okay. Representative Abramson has his hand up. Yes. Yes.
I just have a comment. It's on that fine. It's on page 2, and it's also on page 3, line 2, and another on page 3, line 25, and so forth. I'm just noticing it's just a $50 a day fine. And if you're taking away that 21 day, you know, after 21 days, that looks like it'd be about $1,000 increase in what people are being fined. But the first thought that comes to mind when I look at fines for credit unions and banks and business and whatnot is this going to be borne out disproportionately on small business versus big business? Big business and big companies that sometimes will see a really small fine on something, and they'll just totally they'll disregard the rule and just pay the fine every single day. But small businesses and startups and people trying to get a brand new, say, credit union established, they don't have millions of dollars sitting in the bank, so to speak, to cover everything.
They better have
might be on
millions
a
of dollars in
shoestring.
the bank. They better
What's
have
that?
they better have millions of dollars in the bank. And both banking and insurance, the most important thing you need to know under these institutions is solvency. So that's what our departments are making sure that they are truly solvent and that they can afford to do business. So that's a critical item. Nobody wants to drag out waiting to respond to the banking department. I don't think that this happens very often. So, but I hear your concern, you know, let's make sure we don't hurt the little credit unions or the little banks, but believe you me, they're all in this together, and they want to respond to the department as quickly as possible. So, at any rate, we can certainly think about that one. Is there anybody else? No, I don't see any other hands, so we'll close the public hearing on 3:12. You're supposed to write that, Keith, write the time down. I don't know if I did.
Yeah, I've been keeping up with that.
Okay, so we can close that now, I guess officially. And then we have 4 minutes before the next hearing. So we can take a pause unless anybody has any other questions they'd like to ask me.
Yeah, Representative Hunt, Mr. Chairman.
Yes, yes, go ahead.
Jane, Representative Bowie, you're here.
Yeah.
I will be leaving at 11 for a dentist appointment.
Okay.
And then I'll be back this afternoon, but we'll have to leave at roughly about 2:15.
Okay.
I had some appointments that I couldn't reschedule.
No, and I'm sure that anybody has a vaccine date, they're going to move
Yeah,
along
March.
quickly.
End of March.
So no, we're you know, we understand that everybody comes and goes, and that's so feel comfortable. I would say is that that having that if someone wants to make sure they can, you can certainly send a text to me, and my phone number is on the webpage. So anybody feel free to text me if they want me to know that why they're leaving. And obviously if your name disappears from the screen, then you're obviously not in the room. And but that I would ask people that if you do get up to leave, do turn your camera off, so we don't necessarily see an empty seat, but just that feel free to turn the camera off, especially if you're getting up from your seat. Sometimes it might be best that we didn't see what pants you were wearing that day. But
And should we leave? Should we leave the meeting and then log back in once we get back?
That's probably the best thing to do.
Okay.
I
All
think
right,
that's
thanks.
appropriate. Yeah. Because it's better for me to know you're not around rather than see your name and then go call for you when you're not there. And yeah, that's probably the best thing.
So I'll take attendance for each bill based on. the
No, I
participants
wouldn't worry
list.
about that. I think the attendance is just the morning, and but we know full well that people can come and go with attendance.
So the form that the House clerk gave me has like an attendance list for each bill.
Really?
Yeah.
I don't know, Pam. Are we supposed to roll call it for each bill? No.
That's
Not
new
roll-
to me. Yeah.
Not roll call, but it says he said to like all the names are in bold, unbold the members' names who were not present, and that's on each form for each bill.
Mr. Chair, when I did the clerking, I did just visually update the names that were on the bill so that I actually did take attendance for each individual bill.
That is true. When we would always circle when we were having a hearing, we would circle who was there.
But no,
That's what it was for. So yeah, so that if the person is, I don't know if you need to take a roll call, but yeah.
Maybe could you let me know?
Yes, I let me follow up on that to find out, because you're not a host, so you wouldn't necessarily. But you can see all the people who are there, right?
You can
Well,
see the panelists.
Right,
Yeah.
but I can see the list of panelists. I can see a very long list that I'll have to sort through depending on how many people are on the call.
Yeah, right. Because everybody should have rep next to their name. So yeah. So when we start a hearing, theoretically you should, circle, or in the old days we would circle it on the clerk's sheet, but to identify who's here and who's not here. So
Okay. I think doing that I'll miss some testimony, but if people could just let me know that they're leaving, that would also be helpful.
Yeah. Okay. We can work that way. All right. So now it's 10 o'clock. So I guess we'll open up the public hearing on the next bill. Okay. So the next bill is where are we at 70, House Bill 76. Okay, prohibiting paper billing fees. All right, so you've updated that. I see that by renaming the room, I see that Pam, that you can then identify that we're now on to the next bill. Okay, so I would ask Max, you have your hand up. You have a question, Max?
Yeah, I just wanted to make a point on the packets that I'm also missing quite a few bills.
Right.
In
Well,
fact, for a
evidently
couple
they didn't
bills
come
I've
back
got.
from the printer. Yeah, they didn't come back from the printer yet.
I also noticed in the calendar that I've got a hearing at 1:20 where I've got to go introduce a bill, and we'll be in session right at that time. Amateur radio antennas.
Okay, well, we understand. All right, so I'm now going to go to the attendees. So the sponsor, raise your hand. Okay, there she is. All right, and I am now going to promote you to panelist. And we'll be rejoining the webinar as a panelist. So I think you're on. Are you on?
Yes, I am. Thank you so much, Mr.
Okay.
Chair. I do love your background, though.
Thank you. Yes.
All right. Well, thank you. Thank you, members of the committee. I'm here today to introduce you the House Bill 76 FN, prohibiting paper billing fee. As you can see, this bill has a strong bipartisan sponsorship. The growing trend of business and credit card companies to charge consumers for paper billing has and was brought to my attention by a constituent who is retired in my district. I share this constituent's concern about how those fees penalize people on a fixed income. Families struggle to make ends meet, people who live in a rural area without dependable access to the internet, and those who are simply uncomfortable with the risk of putting their financial information online. The pandemic has even made household finances even harder for many, where every penny does count. According to the National Consumer League, consumer group in the United States, Canada, Europe, and Australia have all reported increasing numbers of companies that have begun charging customers who wish to receive and mail in paper bills. Those charges are often presented as, quote, good news, end quote, by offering discounts for, quote, going paperless, end quote. Some are going further by offering additional discount to those who agree to turn over banking information to allow the companies to deduct their charges directly from the consumer's bank account. Paperless billing is a good news for many people, those who have a computer, stable internet, and stable income, but not for everyone. It's not a good news for some New Hampshire residents. The National Consumer League cites a typical paper billing charges nationally of $3.50 a month. I spoke with a New Hampshire family. Those cell phone bills providers offer a $40 a month discount if they were paperless and provided access to their bank account for auto pay. This is clearly a discriminatory practice that penalizes those on a fixed income, people with access to the internet or computer, often low-income citizens, and honestly, any family working hard to meet their many financial obligations. How many people can be sure that their checking account balance will be enough to cover one or more monthly bills on a date that the business wants to debit their account? According to a survey conducted by the research company Toluna USA, 86% of American consumers believe that they should not be charged more as a result of opting for a paper bill. I suggest if committee members contacted their own constituents on this question, they would find a similar result. This pandemic has brought forth many studies and statistics on how many people do not have adequate internet service. An article in the New Hampshire Business Review stated that 45 to 55% of people in many communities in New Hampshire said the internet service was not adequate for their needs. You might also be thinking of environment and that avoiding paper billing saves trees. Truthfully, a minority of New Hampshire residents will likely opt in for this service. An InfoTrends study showed about 25% of people will opt in for the paper. They do this for a certain type of bills, such as medical bills, where privacy is important, and for other bills, not for all of them. We should be thinking of those who need this service. Once your private records are on the internet and perhaps fall into the wrong hands, are compromised or hacked into, it can take years to repair your credit history, and you might suffer identity theft and never feel quite safe again. Having an alternative option for New Hampshire residents is ideal. Finances are not the only reason for opting for paper. Often it's for privacy reasons, as the case of those who wants to keep their medical records private. My informal research showed that a number of thriving New Hampshire utilities, which are of course in a different category, such as Eversource and TDS Telecom, do not charge extra for paper billing. They understand the needs. This also tells me that they likely face no substantial hardship from continuing to offer customers their own free choice when it comes to billing method without charging penalties. I hope you like I hope you will keep those points in mind and choose to vote in favor of the House Bill 76FN, an act prohibiting paper billing fees. It's a very simple step we can take in a bipartisan way to provide a great and necessary benefit to our constituents and to the people of our state. Thank you so much, Mr. Speaker.
Thank you. And I assume you're willing to take questions?
Sure, I'll take a question.
Okay.
Can I interject? This is the clerk.
Yes.
Representative Wazer, would you or have you submitted written testimony?
Yes, I have last night.
Okay, thank you.
Great. Okay, so Representative Van Houten's first up.
Thank you very much. Thank you, Representative, for bringing this and for taking my questions. I actually have two quick ones. I noted that between last year's bill and this year's bill, you added the clause for paying by mail. Does that seem to be becoming a greater problem? Are more people charging for those who pay by mail?
Yes, that is one of the reasons that I'm proposing this bill, because a lot of our constituents are been seeing some additional fees when they are requesting a paper billing.
But follow-up, please.
Yes, further question, Inquirer.
Is that also true when they send mail-in payments? They're being charged for those? In other words, if I send a payment of $50 in that I'm due, am I going to be charged a fee on top of that?
I don't think I understand the question right, but if you are asking for a paper bill to send out to you, and that's basically they are charging you for it.
Follow up. I'm just looking at the analysis that says for paying by mail, and
I wouldn't read the analysis, but you're concerned that you're in the actual language of the bill that there's a fee being charged for paying through mailing it back rather than. Okay, so we'll dig into that, but I would not lay on the analysis. Analysis can be confusing sometimes. So
that is in the bill, though.
So it is in the bill. Okay.
For electing to make a payment by United States mail.
Or electing to make payment. Right. So are they back billing you for that? I don't know. That's a good question.
I don't know.
Okay. Are you all set? Any more questions?
I do have one other question. Do you see any problem with the enforcement clause that is included here, given that the Department of Justice will be responsible for this and there are some heavy duty fines that are levied here?
I don't see any problem with that. I have spoken with a lawyer and about this to make sure that businesses are not taking advantage of it. So making sure that it's been heavily put the fine in there, so that way if a consumer opts in for a paper, and so that way they cannot charge it. And for that matter, we are trying to protect our citizens of New Hampshire who is desperate for their paper billings rather than letting them to be fined. I mean, being charged for a fee. So having this heavy fee, I think would be beneficial to kind of convince the businesses to let the choice for the consumers.
Thank you very much.
Yeah, so I would interject before I take more questions, just to make sure everybody understands. This is under 350-59, which is follows under the Consumer Protection Statutes. So just so everybody knows, technically, in actuality, any financial institutions, banks, securities, insurance, and public utility commissions are exempted from this statute. So if it's a utility or if it's a bank that's charging for this statement, they would be exempt from this legislation. Okay, so next up is Anita Rose, Representative Rose.
Yes, thank you, Representative, for taking my question. It's just a quick one. I'm just curious, why is the term person used in the bill rather than corporate entity? And because it's saying that persons will be will be fined. So, why is it not a corporate entity? Because individuals.
Usually in penalties, they'll have both. They'll say person and then they'll say a person fine. Yeah. I guess under 358, then in terms of if there's somewhere else where it talks about a person being a business, then it's
That's correct, Mr. Chairman. I can tell you that under
Yeah,
statutory construction
right.
law, that
Yeah, under
person
construction,
is defined as a corporation as well as an individual.
Thank you, Pam. This is
Yes.
great having you here right behind me. It's good. Okay. And any other questions? You all set? Anita? Okay. Representative Aberson is next.
Thank you, Mr. Chair, and thank you, Representative Wazir, for taking my question. I'm noticing that you've exempted state agencies from this.
Yes, I have exempted state agencies due to be honest with you, I think the state itself needs the revenues, and according to what I heard from the last year testimony, that they bring forth about $75,000, I believe, in revenues according to that. So I think the state of New Hampshire needs the revenue, so I make sure that we exempt that.
So I
For the
guess
question, you may inquire.
I'm sorry.
You're
Follow up.
supposed to say, can I have a, yeah, go ahead, go ahead.
So it just seems like it's the state applying rules to certain types of businesses and then exempting itself, and for pretty hefty fines, $500 on the first offense, which is pretty significant for a small business or a startup, and then $5,000 for a second offense. I think we'd see a lot more of the $500 first offense penalties. That's quite a bit of money. And then on top of that, somebody's going to be asking me the question when they get hit with this, can the state charge you an extra fee for trying to pay that $500 fine by mail?
I mean, first of all, if this bill passes through and becomes a law, and those businesses should be considering in following the law. So if they really want to pay that $500, then they can charge the consumer and, take it up to the court. So it's better off for them not to charge that $2 fee and not get fined. So that is the exception of this, to follow the rule or not to follow the rule.
Okay. You
have-
further question, Max? Yeah,
Yes, my
Representative.
follow-up is there are all sorts of different types of businesses. Every time we come up with a fee or a fine or a regulation, there's always some new startup that hits all the regulations that we come up with for existing established businesses that we know of. And you may have a business that provides some type of internet service or internet billing service, and for them, the cost of processing paper, paper bills like these. Oops.
You're not supposed to show things.
Oh. Their cost of processing by paper could be as much as $20 per bill. So they may set up something that's done exclusively through online billing, but then if they want to make a slight change and except for an exceptional circumstance, their processing costs could be very high. Are they supposed to just eat the processing costs themselves?
Thanks for that question, Representative Everson. As you can see, this is not new, okay? So companies has done providing mail-in bills previously, and as we are just moving with technology, it's become a new thing for online billing or online payment. So like I said earlier on my testimony, that very little majority of our New Hampshire citizens could opt into this. So there won't be too much of a big burden for the businesses. It's just allowing an option for our individuals to opt in or to stay in as of, opt in for the paper or pay online. So just giving that option for individuals would be good. Just like our state motto, live free or die.
Okay, Representative Ham has a question.
Yes, thank you, Mr. Chairman. I too was wondering, part two, nothing in this applies to governmental agencies along the same lines. Does that include all governmental agencies, towns, and there are many types of governmental agencies and many types of consumers or folks that are paying bills and their ability to do so on the internet. So I was just wondering if this applies to all of them, including municipalities.
Yes, all the New Hampshire businesses that are entitled to the state.
Okay, and Representative Terry.
Thank you, Mr. Chairman. Representative Wazir and colleagues on the committee, I want to make clear that I'm in an investigatory or inquiry mode here. So my question should not be taken as indicating any position at this point on your proposed legislation.
I'll be the judge of that.
Excuse me?
I said, I will be the judge of your question, because I might say to you, would you believe? If I decide that your question was not a question. So, go ahead.
Clearly and indisputably, I think we can consider the charges that are levied to pay, to receive a paper bill, to be a kind of user fee. If in fact we prohibit any charges for levying such a user fee, then somebody's going to have to pay. And the people who are going to have to pay are the people who are paying electronically. Have you given any consideration to how those who opt to pay electronically would be protected if your legislation was to pass? Protected in the sense that they would not end up having to pay for the people who are choosing to continue to pay via the traditional old method of paper billing. Is that a question, Mr. Chairman?
That's a question.
Thank you.
Well, thank you, Representative Terry. That is a similar question to the previous answer that I gave, but it's obviously the businesses already have done providing paper billing previous years, before, like 5 years ago, 7 years ago, before we came into this technology. No, you will not be charged extra for those who are opt-in for online banking. You will pay your share, and it will be a great thing for the business to provide for those who wants to be opt-in for paper. So it will not make any it will not make additional fees for your perspective. If you
I think what he's implying is that a business would intend that there's a certain amount of percentage of people who will pay the fee, and if all of a sudden they're not getting that fee anymore, then they're going to pass on that cost, whatever revenue they thought they were going to get, that they're going to pass that cost. It's going to offset some costs. They're going to pass that cost on to everybody. So therefore, the rest of us who really are still paying electronically are subsidizing this benefit for those who can't afford it.
Well, I don't have an answer to that, Mr. Chair, but it does come up a question for me. If the businesses were able to provide hard copy of a statement or billing previous years, many years ago, how they were covering their charges, how they were coming up with those extra charges that they are now putting on our consumers. So I would like to know that answer. If a business is
well, I can venture to give you an answer to that one. Just like in the old days, airlines never charged for luggage, and now they do. And what's happened is that they lowered their ticket prices, but then added fees. So I think what Representative Terry is going with this is the exact same thing, that if you are removing the fee collection, therefore they will have to raise their prices for whatever product they're selling to offset that lost revenue.
Well, I don't have that answer to that, Mr. Chair.
Representative Terry, was I on the mark or not?
Well, Mr. Chairman, I was actually going to follow up with questions that would have been stated in a very similar manner. But I would like to thank you for what I did not anticipate to be a tag team on this question. And thank you for saying what I didn't have to say or asking what I didn't have to ask. Thank you very much. You read my mind.
Okay, perfect. Okay, Representative Abel is next.
Thank you, Representative, for your testimony. I want to make sure that I'm clear on one issue. I believe that this bill, while it would prohibit additional fees for someone who transacts business by paper or by mail, would not prohibit a business from offering a discount or a rebate for electing to make an electronic transaction. Is that correct? It doesn't. The business still has the right to give an incentive to someone who goes electronic and discounts.
Yes,
correct.
You are correct.
Thank you.
And Mr. Chair, I'll end my questions from here. I would like to leave to other members if you would like to testify.
Okay, fair enough. Thank you. So I would ask for those people who raise their hands to put them down. And so the next up is Walter Stapleton. Is he a rep? No. See, I guess.
Yes, he is.
He's a rep. Okay. It doesn't say, it just says myself. Okay. So Walter, I am now going to promote you and as a panelist. And go ahead, Walter. And I'm going to just demote you. Hope you don't mind. And are you up, Walt?
Yes, he's here.
Okay. Make sure.
Thank you, Mr. Chair and members of the committee. Walt Stapleton, Claremont Ward 3 Representative, Sullivan County District 5. And I'm also a co-sponsor to this bill, HB 76FN. I believe that invoicing is an expected, usual, and basic responsibility of a business relating their charges for services and goods to their customers. And as a matter of customer service, should be done in the medium and the usually expected ways that we're accustomed to receiving. Now, we are on the threshold of electronics and internet, but there are many people out there that do not have that capability, or it's intermittent in its effectiveness. And many people, while they do have the capability and are involved with computers, in my experience, they're not often looking at their obligations or their emails. I've got a case where in other venues and organizations, I'm almost at the point of just using emails because nobody's reading them. And that's a problem because people miss things and they could be missing their billing if they don't go on to the vendor's website or look at the vendor's email that contains an invoice. So I think it's an unfair thing to expect ubiquitous observation of emails and websites. We're seeing the effect of more and more companies and financial institution banks wanting to convert to green paperless, and that's a good thing. But that has to be for those people who want that and are capable of doing it. That should not be forced upon the general consumer, and especially not those people who don't have the capability or don't have the management capability to monitor and keep up with all the many bills that could come electronically. And then, of course, when the electronic means fails for hurricanes or storms or outages, so there's also that specter of fees, late fees for missing or late turn in of of the payment on these bills. So I'm in support of this, and this is like a preemptive defense against a movement towards removing paper from the culture and the commerce. And I think we do need to have the paper, and for those that can't use or don't want to use the other capability that we're developing electronically. And I guess that summarizes my feeling of support for HB 76FN. Thank you.
All right, thank you. Do we have questions? You have Representative Greason, you have a question?
Yeah, I thank you, Mr. Chairman, and maybe because you addressed this a little bit earlier when you said that according to statute, there are actually some entities that would be exempt from this legislation anyway. Am I understanding this correctly, that banks would be exempt, the utilities would be exempt from this? We already, I know that the state would be exempt. And am I understanding that towns and counties would be exempt? So who exactly would this apply to? Bob's Garage, what? Thank you.
I'm anticipating that a large number of people and who use anything from the local garage or vendors or contractors that come into the home. There's a whole array of businesses out there that you could lump into that will still use the paper billing with a good effect in relating to their customers for the charges for the services and the goods that they provide. I would prefer that those exempt organizations would also respect people's inability to deal with the internet and continue a paper billing on a courtesy, if not on an obligatory fashion. I think that's just good customer service, good business to aid your customers in paying their bills.
Mr. Chairman, can I follow this up?
Sir, you can do a follow-up question, yes.
Thank you, sir. I appreciate it. And thank you, Representative Stapleton. So how could, I mean, just thinking, putting on my devil's advocate cap here, how could I at Bob's Garage just not send out a paper statement and then just have sort of like all these companies have shipping and handling charges? Shipping is the cost of actually sending the product, and the handling is some mysterious charge, the cardboard box, the envelope, the stamp, all that other sort of stuff. So how do I not just put shipping and handling or something along those natures in my bill and send it to you? And it's basically getting around this legislation. It's not a fee for doing paper billing. It's my shipping and handling fee.
Yeah, we probably.
I don't misunderstand. This is devil's advocate. I'm not advocating skirting the law. It's devil's advocate.
Yeah, you asked the question. Okay, that's good.
Yeah, I think that's a great question, and I think it's already happening. You know, you buy an item and it's discounted, and it's the best on the Amazon or the internet for $9.95. Everybody else is $15, and then you get to the checkout, and then the shipping and handling is $15.95. And then you got to cancel that and go back and find out who's got the free shipping so that you can get the real price, the real all-in price. And you know, when I'm faced with that, I'm looking at that vendor and I'm saying, okay, they're going to play this shell game trick. Here's one price, but when you get to the checkout, here's another. Which shell is the P underneath of? And then I'm going to decline to go to that vendor ever again, because I know the tricks that they're going to play. And I've been in business myself, and fair billing, clear billing, paper billing is what I always used, and be prepared to defend your bill and be fair with all of the peripheral charges and the assessments that you make on that bill. That bill is a testimony of how well you do business and how well your attitude to customer service is. And it goes hand in hand with the estimate, which is also generally a paper thing, but can be electronic. sometimes I think in the society, we don't give enough attention to the clerical aspects of running a business and making it clear and helpful for people to be able to read, understand, follow, and pay their invoices.
Great. Representative Aberson is next in line for a question.
Okay, so this rule applies. This isn't a consumer protection for New Hampshire consumers. This is a restriction on businesses or a fine for businesses that make the mistake of moving to New Hampshire, because they're the ones that would be hit by this. But I'm still looking at this and I'm thinking, okay, if you have a business that is trying to offer some kind of discount for people who do the electronic payment, they want to pass that on. That looks like it's still a price differential. How do you guarantee that you can avoid the fine, or is somebody going to be caught unawares, not realizing that they're going to be hit with this fine for offering a discount?
Yeah, I don't see in the bill any against that or mention of it. And I think once again, it goes to fair business practice. We already if you're a
Rep
state-
Stapleton, could you make sure you're not rubbing your phone against your facial hair or your shirt or something like that?
What
Thank
it
you.
is.
I get the paper in front of me. Sorry about that.
Yeah.
Okay. We already do that when we give discounts for senior citizens and or volume discounts. Why can't we give one for electronic use and to
Certainly.
save that customer? That's the incentive for the customer to compromise away from the paper billing. I think that's in line with what we're already doing, and I don't think the bill prohibits that or affects it.
Follow up?
Okay, yes, sir. Further question. All right, further question.
The bill just says, no person shall charge a consumer an additional rate or fee for electing to make a payment by United States mail or receiving paper billing statement. That means that any differential between electronic and paying by paper. So they're not, if there's a discount offered to pay electronically, then there effectively is a different rate charged. And this is what this is saying, an additional rate or fee, additional rate or fee. So it's two different rates. So how do you guarantee that you don't get caught by this, and get hit with the fine?
Well, I would say that the difference is if you're going to charge a fee for a paper billing, that's an upfront charge. And if you're not going to charge the fee, but you may give a discount for an electronic billing, that would be a back-end charge or discount. What the bill is trying to do is prevent a wholesale sweep into a movement where you're going to eliminate the paper billing and affect those people.
Do it again. Yeah. Okay. Good. I thought it was static on the phone line, but I don't know what you're doing with your hands or.
I'm basically still, but
maybe it is.
maybe we've got some phone interference.
Some kind of interference. Yeah. It's some. Okay. All right. So I think we'll move on, Max. So Representative Terry.
Thank you, Mr. Chairman. Representative Stapleton, I'm in sympathy with the thrust of the bill and the central feature of, as I understand it, of not levying additional charges on people who opt to receive a paper bill and go that route. However, I am deeply troubled by the exemptions. And I need to really hear what the rationale is for each of the exemptees in this proposed legislation. First, we're living in a time where there's deep cynicism developing towards double standards. And when we read that the government and utilities, for example, are granted exemptions, people are going to react, many people are going to react in the way that this, once again, these are rules for me, but not for thee. And so I really need, before I can move forward and feel positively about this bill, I need to know what the rationale is for all of these exemptions. It's deeply troubling.
I would have preferred the bill without exemptions, but I'm not the sponsor. I'm a co-sponsor. And that question should really be answered by the sponsor who's worked long and hard on bringing this bill to you. Because I do feel that there should be some further protection, even for those that are listed as exempted. But I'm supporting this bill because I like the direction that it's moving in, away from what the culture is tending to do by discouraging paper billing and paper payment. And I think we have to put the brakes on that. So in my view, I'm supporting this bill because it's a start in the general and the right direction to protect the consumer at the lower end who can't use or doesn't want to use electronic means for payment.
Great. Thank you very much for your testimony. The chair will now call on Diane Schuett, who I am now moving you up to a panelist. Diane.
Thank you, Mr. Chair and members of the committee. My name is Diane Schuett. I represent Merrimack 20, the towns of Chichester and Pembroke. I'm also a co-sponsor on this bill, and I did submit written testimony, but a lot of it repeats what's already been stated. My main thrust with this is protection for seniors who tend to not own computers, not do business online, and depend on paper billing to keep track of things. I will tell you that, number one, I'm a senior citizen myself, but I also help several senior couples in my community, drive them to do shopping, so forth. And for them, a lot of their issues are keeping track of things. We all know that it's less expensive for all of us, the state and our communities, to keep seniors living in their homes as long as possible. And one of the major reasons that they have to abandon living at home and move into nursing homes or whatever is their inability to take care of their own financial matters. I would say, in answer to one of the questions I heard previously about paying utilities and so forth being exempted, I think probably these seniors tend to keep track of those better because it's something that occurs monthly, whereas getting the car fixed and paying Bob's Garage is a random case. And to be honest, I have one couple particularly who constantly have the discussion, did we pay so-and-so? Well, if they've gotten a paper bill and they've kept their portion of that paper bill, which is usually the case, they can look back and see, yes, oh yeah, there it is. I sent the portion with the payment, right. It's a way for them to maintain their financial independence and stay in their homes. I would also point out one of the questions put forward was paying fees for internet billing. And I would submit that most of the people that this bill applies to would not be charging things over the internet. If they don't have a computer to pay their bill, they're probably not buying goods or services over the internet as well. So it's another case that they're not going to be applying this particular fee. And I would also say that if you do opt to pay your bills by internet, the fees that are charged are inherent when you start that process. Most companies that charge fees for internet service, that's implied right from the get-go when you take that option. And I think we all have to be aware that fees, such as the chairman mentioned, for baggage and so forth, are subject to change. So that's about all that I have to add. If there are further questions, I'd be glad to answer.
Representative Van Houten has a question.
Thank you. I think I have more of a would you believe kind of question, but I would just like to throw this out. The vaccination, the COVID vaccination rollout featured many elderly people who only had access to making their registration by means of phone. And would you say that they were, although this isn't quite the same as paper billing, I see it as a parallel. Would you say that that's a case in point to support the need for taking care of these elderly senior citizens?
Definitely one of them. I will say, for those of you who aren't aware, seniors were given the option, seniors and folks that can't afford computers, to call 211 over the telephone, which almost every senior at least have access to telephones. I will point out, I tried to help one of my seniors that I assist, and it took us a half an hour of calling 211 to get through. It was constantly busy, but that was an option rather than making your appointment online yourself. So yeah, that's definitely the part of our population that this bill is aiming to help. I will say also the thought occurred to me when I think it was Representative Terry was talking about exempting utilities and so forth. The only entity that this bill specifically exempts is government entities. Those other billing entities, utilities and so forth, as the chairman mentioned, that's already in the law. We aren't putting that in this, that was already there. So you're going to ask the sponsor of that section of the RSA what they were thinking when they made those exemptions.
Fair enough. So Representative Abramson has a question. We're running up the time here, Max. So
okay, it's quickest question ever. So the bill and these laws in general don't apply to New Hampshire. Oops, my hair's out of place. Don't apply to New Hampshire consumers. They apply to those businesses that move to New Hampshire. So if you have a new startup, or this isn't a startup at all. If Unitil wanted to move their operations from Boston to New Hampshire, they could no longer.
That's not a good example. They're a public utility, so there would be.
Well, if a company wanted to move from sorry, Mr. Chair, if a company wanted to move from Boston to New Hampshire, they would be facing this penalty and the legal question of whether or not they could charge a different rate for paper versus online billing. Is that correct?
Theoretically, they should. Hopefully, they know our laws before they make the decision to move to the state of New Hampshire.
Well, I don't know the law,
but I'm not sure that at this point it's not a law at this moment. So let's
I don't know what the bill would mean. Even looking at it, whether or not they would be penalized for offering the discount.
I hear you. I hear your question. I understand where you're coming from.
Thank you, Mr. Chair. That's exactly the point I would have made also. They know what they're facing when they decide to come here.
Okay, fair enough. Thank you very much. Okay, Suzanne Vale, and I have already upgraded you, Suzanne, so you can go ahead and testify.
Mr. Chair, thank you, Mr. Chairman and honorable colleagues. And thank you for taking my testimony in support of HB 76. I am Representative Suzanne Vale of Nashua Ward 3, and I'm representing both my district and myself, which is Hillsborough 30, and I'm also a co-sponsor of the bill. I have personally experienced difficulty with navigating online statement and payment, the whole revolution really. Here is a small example out of many that I've had. I had a problem with my cell phone service this year. I bought a hotspot equipment in order for my daughter to travel on serious family business. But she wasn't getting the amount of data that we paid for. And I logged into our account and I could see that in fact, the device was now on a different plan. I searched for the transactions that would have caused this. I opened a chat and was told that the online view I was looking at is not kept current for transactions like the one I would be looking for, and that they would not necessarily be reflected in the bill that I would be able to see online. Whether that was true or not, the answer was not online. I would never have been able to resolve this if I weren't grudgingly willing to pay their $2 fee to get the bills. I was able to track the transaction once I got the information and I found the date and the time of mistake. So then I was able to call and ask them to fix what I had found. I can't personally attest that my information was not on their website, but I couldn't find it. And the only way I could fix this is to get the paperwork and turn the computer off and sit down and reconcile it. These fees seem to be levied by companies that really have you over a barrel. We had a serious family emergency going on. We needed that hotspot to be delivering the service that we paid for. I will be staying with the paper bills just as a matter of trust on the basis of that incident, although I've had many. But I really believe that getting it on the paper with that company will give me great efficacy in the problem solving. In other words, I can keep my computer shut and I don't have to worry about it. Now, no one has a $2 a month fee to spare in order to trust their vendor, but I am very fortunate. Now, as a state representative and just as a person in my life, I have a lot of support. There are a lot of people that have broadband that could help me where I'm unable to access it. I have other courses to take in terms of getting help from other people. But calls, emails, and chats that solve nothing are far more serious a problem to people who don't have internet or the resources. Every day, it gets harder for the elderly and disadvantaged people to make it living alone. We can't allow companies to take away the $2 from our residents in order to encourage more streamlined online bill paying and auto-deducting society that we now live in. It's wonderful to see all these amazing technological advances. I'm a kind of a geek and I love it myself. But as my 81-year-old stepdad astutely says, knowledge has a half-life of 5 years nowadays. And I think it's true. What started as a way to encourage folks to pay online is now a way to keep consumers from their own information and the way that they can access it. Time has passed since people would pick up the phone when you have a problem and answer it without asking you to wait online for a year. The original plan that has been executed, I feel, is no longer ethical. 10 years ago, when they wanted to encourage people to pay bills online and receive these things, and it's all very good, but that 10 years has gone by. Large companies do this. I support the fines on the basis of their ability to afford to pay them. I know that telecom companies can afford this, and they can afford to process any kind of payment. I believe that. I have looked around me wherever I go, which isn't far these days, and I see elderly people ask for their phone number, their rewards number, everything under the sun in order to make a cash transaction in a Walgreens. We can't be so indifferent when we're trying to assist people who do not have access or the ability to comprehend the constant change in the way that money transacts today in the changing world. It is my hope that the committee will support the bill, and if they find necessary, to make the necessary amendments that address the questions that arose today. If there's an issue with the smaller companies being affected, you could exempt companies with a small amount of employees in any fashion that you know is legal. I am not an expert. I thank you so much for hearing my anecdotal testimony. And with that, I will take questions the committee members may have.
Okay, I don't see any hands up. So I think you're, Representative McLeod. has a question.
What if a company opted out of mail billing altogether and they said they would only bill online? How would this bill affect them?
I don't think I can answer that question, but as I was looking into the bill originally, when it was filed the first time, I found that I think it's against federal law. So I don't want to say for sure, but I think there's some federal legislation that prevents people from not giving a statement of any kind on paper.
Yeah, I don't know anything about that, but I would say that in your example of using a cell phone company, cell phone companies are not regulated by the PUC, so they would not be exempt from this statute. And the assumption would be is, the reason that is true, is that there is a free market that you can choose and shop around when it comes to cell phone companies. And so therefore there was no need for the public utilities to be involved in regulating that industry. So. Seeing no more questions. Representative Abramson, we're out of time, Max, so make it quick.
Okay, as quick as I can. So you say you had two companies. This doesn't apply to New Hampshire consumers. It applies to New Hampshire businesses that do business in New Hampshire.
Correct.
So if you have a New Hampshire billing company and they're competing with somebody in Massachusetts, is this now putting the New Hampshire company at a competitive disadvantage?
Not in my opinion. Not in my opinion. I come from a land where if you pay cash, you get a discount. That's the way it is at my printer. And you all know how much the house depends on printed material. So what I can say about interstate commerce is that I know when the laws get stricter in California, they seem to get stricter everywhere. And that's supposed to be a joke, so.
Well, we don't want to throw other states under the bus. All right. Well, thank you very much. And we see, let's see, I got a bunch of people who did not testify, but would like to weigh in here on the blue sheet. Rebecca Williams, Representative Williams, is in support of the bill. And we have Nicole Forty. She's a member of the public and she is in support of the bill. I have a Jared Cape, who is, all I know is he's got a Dartmouth email address and he's opposed to the bill. I have Lucy Covello, who is a member of the public and supports the bill. And I have a Eric Rathbun, who is a member of the public and is opposed to the bill. I have Josh Yokola, who is an elected official, so he's a state rep, Josh, and he is opposed to the bill. I have Representative Mary Beth Walls, and she is in support of the bill. And we have Representative Linda Gould, who is also in support of the bill. Tom Dolan, Representative Dolan, in support of the bill. And then we have Alvin C., who's a member of the public, who's opposed to the bill. And we have Ryan Hale, the New Hampshire Bankers Association, who is opposed to the bill. And with that, we'll close the public hearing on House Bill 76. And as I said before, this Bill 76 is an early bill, along with the first one we heard, 610. So I will try to do schedule exec sessions fairly quickly. I think it's going to be, let's say, the third day that we meet is when I have a schedule in for their exec sessions. Given the time is 10:56, so we'll now move on to our last bill for this morning. And that is House Bill 475. So I would ask the sponsor to raise your hand so you would pop to the top of my list. And there's Jordan. And okay, Jordan, I am going to promote you to a panel. Oh, geez, it moves around on me, jump around, promote you to a panelist. And Representative Ulrey, you're recognized to introduce the bill.
As soon as I finally got a mute button.
There you go.
Very good. Thank you. My name is Jordan Ullery, Hillsborough 37. This bill was introduced because of several consumer complaints that have been received regarding individuals, businesses, entities copying their driver's license, and then the constituent began receiving all sorts of unsolicited advertising materials affiliated with that particular entity. It actually happened with me when I got a new transmission put in my truck over at Tully Buick in Nashua. They photocopied the driver's license, and I said, well, RSA 260.14 says you can't do that. And they said, well, do you want your transmission or not? That's a problem. You'll notice I sent out to you a proposed amendment to this to address some of the concerns of the pharmaceutical entities by Mr. Stout. I would like for you to consider that if at all possible, and as language, it makes sense. The key section of this is down in line 9, paragraph C, which says that if they're going to look at your license, then they have to provide you with a copy of the driver privacy protection policy of the business. Now, that business is required under federal law, it's the DPPA, you love acronyms, the Federal Driver Privacy Protection Act, which means that any entity using a driver's license has to have a policy in effect protecting the privacy of the driver license information. Your driver's license has a lot of information on it. Your name, your address, under the Fair Credit Protection Act and the Fair Debt Collection Protection Act. That information is considered private personal information and is protected by federal law. You're supposed to keep it secure from any outside entity. And just like when you sign up online for something, they have to disclose that they're going to be using it for that purpose. Currently in New Hampshire, that doesn't happen. In the particular instance involves the largest pharmaceutical pharmacy business in the United States, CVS, went over, and apparently Nashua maintains a large supply of drugs, opioid drugs that they don't have in their smaller areas. So they're forcing people to go to one location, which is a good idea. They demand the identity of the person picking up the drugs. That's perfectly fine. There's no problem with that. But then they take the driver's license and copy it, and like one person said, they scanned it in, which again is a violation of New Hampshire state law. So apparently, when confronted on this, they said that the Nashua police instructed them that they had to do it. Well, if the Nashua police are saying that they have to violate 260.14, then the Nashua police need to have a lesson in consumer protection law and the Driver Privacy Protection Act, which probably is a good idea anyway. But for all the police departments, not just Nashua. The situation is that there needs some more clarification, some more strengthening of this. You will also see in your inboxes a letter from former Representative Neil Kirk, he and I didn't see eye to eye on a lot of things, as your chair knows, but he's also in favor of this bill with perhaps the addition of the amendment suggested by the pharmacies. With that, I will take any questions and be glad to answer them.
Okay, I don't see any hands up yet, but Representative, make sure I understand what you said was that anybody could use the license, but they have to have a written policy, or they have to have a policy of ensuring the privacy of that driver's license information.
That's correct.
That's what I'm saying, correct? Well, because that's a kind of a few for me, because as some people might know, I rent my castle here, and when I rented, not standing that some people can book directly through VRBO, but when people book with me directly, I actually ask for their credit for their driver's license, and some of them send me very nice. I got a 3x5 nice picture card of someone's driver's license, and the purpose of my doing it is that I'm letting people come in, live in my house. So I like to match up, make sure that when they send me their contract and the check that they pay me with, which can sometimes be sketchy, is I want to like to have the driver's license match up with that. But more importantly is that we have an age requirement, they have to be 30. So I like to make sure that just because they said they're 30, that I actually have documentation of it. So as long as we have a policy about how we protect the privacy of that driver's license. So I'm not breaking the law, hopefully.
Yeah, so long as you have a policy, that's what it says in paragraph C, line.
Okay.
Well, it's
right. I don't need it. Just need to be assured. Okay. Representative Abramson has his hand up.
Sorry, actually, that was kind of my question. You're just saying that you just want them to have a policy. So if they take your driver's license and photocopy it and keep a copy of it for some amount of time, wouldn't it make more sense to limit the amount of time that they could keep it, say 90 days or 30 days or something, and then destroy the paper so that you don't have that material lying around?
I am not objecting to that at all. I am objecting to them scanning the driver's license because there's some information on the magnetic strip that is law enforcement oriented. Excuse me while I cough. Some of the information on the magnetic strip is proprietary, and if it's scanned in, then they have to go back in and scan it. But I have no objection to adding to that. The key thing is that businesses and law enforcement need to understand that there is a existing law, RSA 26014, and this in consumer protection would then also enhance that by saying you have to protect this information if you want to be in business and if you want to demand that information. It's as simple as that. And to answer your chairman's comment about having a policy, you can just say my policy is that I follow the federal DPPA, which means you don't share it with anyone unless you're giving, unless there's a positive consent to share that information. But yeah, I can see maintaining a time limit. Thank you, Max.
Okay. Okay. Follow-up question? Sure.
All right. So this only applies to reproduction or copying. This wouldn't apply to, just somebody looking at the driver's license. It's only if they're making a copy, you want them to have a policy?
Correct. If they make a copy or maintain the information. Going up to a pharmacy and saying I'm picking up some hydrocodone because I broke my ribs, and I did earlier last year, late in the fall. And showing your license to show that you are who the person on the prescription is, that's common sense. But making a copy of it and then perhaps giving that copy to the police department later of all the people that got hydrocodone, that's a little bit too far.
Okay.
Thank you.
Representative Burrows.
Yes, thank you for taking my question, Representative. Just a quick question. Do you know how extensive a problem there is other than the anecdotal, evidence that you had with the transmission?
Well, I've had several people contact me on that. Most of them have been dealing with the drug companies in Nashua or the pharmacies in Nashua. We don't really have any drug companies, but the pharmacies in Nashua. And of course, I'm in this area. I've also, in some of my fraternal activities, had coffee discussions with individuals where this has become common practice for them to make a copy of your driver's license for if you're paying by check. And yet, one of Mr. Kirk's, or former Representative Kirk's, primary things was to prevent the placing of the driver's license number on a commercial paper that is spread out everywhere. So they're circumventing the intent of existing law. So I think this just tightens it up a little bit and clarifies it, but at the same time doesn't place an excessive burden on the businesses. And I'm open to suggestions for making more better wording.
Okay. Let's see. no other hands up.
Chair.
Oh, yeah, okay. See, I got this problem with the committee room. Yeah, you, yes.
Get your
Representative,
binoculars out.
yeah, Representative Johnson, please.
Thank you, Mr. Chair.
You have to speak loud now, too.
My one question is, how does this affect?
Oh, you're leaking out now. The microphone's not even picking you up.
Oh, you can't hear me at
This
all?
doesn't work. Yeah, do you mind walking? I don't know, maybe the micro, can you see where the microphone is?
Is this better?
Yes, there you go.
So my question is, how does this affect the, going in? Oh,
Oh, you're dying out again. You were there and then all of a sudden, I don't know. Is that you, Aaron, in the room? Yeah, okay, there's Aaron. Okay, thank you.
How does this affect going into and registering to vote and showing ID? Because you need your ID, they need that paperwork and they need to see. So how does that affect that?
It doesn't affect it at all because you're merely showing your driver's license. They're not copying the information.
And okay, yep.
okay.
All right, any other questions from the committee members? And did anybody else, did anybody else was going to testify, Jordan, or is it was just you right now?
There are two emails that should be in the committee.
Yeah, we do have some files. Yep, we got that. Okay. All right, so then we're just by reading the blue sheet, assuming that's it for questions. Let's see, Marty Mobley from the insurance department, which is neutral, but they would technically be exempt. Eric Rathman, member of the public and supports the bill. Representative Tom Floza, okay, and he also supports the bill. Curtis Berry, a lobbyist for the New Hampshire Retail Association, is opposed to the bill. Dan Bennett from the Auto Dealers Association is also opposed to the bill. And we just heard from Jordan, Representative Linda Gould, and she is in support of the bill. And finally, Paul Sanderson from the New Hampshire Fish and Game Department is opposed to the bill. And with that, we will close the public hearing on House Bill 475. All right. Well, amazing how that one didn't take as long as I thought it would take. Okay. So at this point, we are going to go in recess until at 1:15.
Excuse me, Mr. Chairman, there's one more morning bill.
There's another bill? Oh, I thought I had. Oh,
House Bill 109, and that's also Representative Alderey's bill, so.
How do I? Oh, okay.
That was good planning.
Oh, for some reason I thought it was after lunch. Okay. So that's at 10:45. So we're past that moment. So we can no, that was at 11:15. Oh, where am I?
Right,
Okay.
you have 5 minutes.
Okay.
You're almost perfect.
Okay, so everybody can take a break for 5 minutes. Sorry about that. Somehow I thought that was 1:15. Not looking at my paper correctly.
John, can I ask you a question?
Yes, go ahead, Jordan.
How can an agency be anything but neutral?
They are.
Well, I'm my guess it's an agency, notwithstanding the insurance department, which is exempt, but I don't know. I don't know why she felt compelled to do that. We'll have, next time I see Marty, I'll ask her.
Yeah, it's the same question I ask in Ways and Means when one of the agencies come in. Your job is type thing.
Yeah, well, we certainly, for instance, we have the agency bills, and they're certainly in support of their own bills. They can't be neutral on their own bills. Right?
It's just a pet peeve. I would prefer them to come in and say, this would have the effect of, and why they're either.
Yeah. I like you say, I'll have to ask her why she did that, but maybe I don't know. I think she might have put herself on the list just so in case somebody had a question about insurance or something maybe, but so.
Yeah.
Right.
No problem.
Okay, so Aaron, I do see you, and Mr. Speaker, how are you? The question I have is I can't see if the two members in the committee rooms don't have computers. I don't know. I can't really see them if they want a question because it's so puny. Even though I've got it on full screen here, I can barely see. So if you speak, you could jump up to the front of my screen, I assume, right? I can't even hear anything. Are you guys, is it?
It's not muted in the committee room.
Yeah, I see it's not muted, but the microphone, I see Aaron disappearing. So maybe Aaron's working on the microphone?
He's near the monitor and the computer up in front, and
Yeah.
the big speaker is, but I don't know what he's doing.
Yeah. Hi, Aaron.
Waiting.
You look like one of the, what is those cartoon characters that talk about scary movies and the editorialize, they pop up at the bottom of the screen.
And Mr. Chairman, I do see that Jody Grimbalist has her hand up. I don't know.
Oh, over in attendees.
Over in attendees. I don't know what she may want to say, but.
Okay, let me click on her. Yes, Jody, did you want to testify on that bill, or did you? You can unmute. There you go.
I did. I had signed up through the testimony system. I don't know if that showed up, but
Yeah. Unfortunately, what time did you do that?
I did it this morning when I learned about the bill.
And I printed them out, at 30 minutes before the hearing, or maybe 15 minutes for the first hearing, right?
Well, and I had said to you, Pam, that, and I'm sorry about this, Jody, because I was going to say to people that if you want to speak, make sure you raise your hand, but I just didn't see it. I'm sorry. When did you raise your hand? Did you raise your hand before we closed the hearing?
I did, because you had said that there was nobody else left to speak, so I raised it. But again, you may not have seen it if I was on the other.
And yeah, what I was looking at, but again, yeah, sorry about that. But you can certainly submit written testimony for the committee.
I will do that, and I will check into the CVS issue that was mentioned in Nashua, because that was new to us.
Okay. Oh, that's one of your clients. Okay, great. All right, appreciate it.
Could I get copied on that, John, please?
I will certainly, when I get her testimony, I will forward it to you. Yes.
I will send it to you as well, Representative Baldwin.
That would be great. Thank you, Jody.
Yep, I will.
Thank you, Jody.
Okay, now you can lower your hand, Jody. Well, I can do it for you, right? Yeah, I can. Lower hand. There you go. I lowered your hand. Oh, talking still permitted. Disable talking. I'm going to disable you. Sorry. Okay. Well, that went okay. So far, so good. All right. So it's 11:15. And do I still have my clerk? Keith, are you still there? Yep. All right. So we'll open up the public hearing on our 11 House Bill 109, and hear from the primary sponsor, Representative Ulrich. Good morning, Representative Ulrich.
Good morning, Mr. Chairman, and I haven't seen you in at least 30 minutes. For the record, my name is Jordan Ullery, representing Hillsborough 37, Hudson and Pelham, down in the southern part of the state. This bill had been introduced last year, and it didn't go very far. But I think it's important that we take into consideration what is too often happening with consumers. And this goes back, I think, a little bit to the bill heard that I came in on, HB 76, regarding paperless billing. What has happened, and what I've got several seniors that have called me and complained, is that all of a sudden their credit rating goes down, or they get a notice from a credit company, a credit collection company, and they didn't know that they owed a balance on their hospital bill, or that they didn't or that they owed something on a consumer transaction, a balance that they had no idea. We all know that the United States Postal Service does an excellent job when they do an excellent job. I just got a Christmas card yesterday. Oftentimes, too often, the mail doesn't come directly through. What does come through is the priority post, although it sometimes takes long for that. I had some paperwork that I was trying to deliver to an individual. It took 6 weeks to get from Braintree to Hudson. I could have walked down and back in that time. Well, maybe not. But the thing is, if you're going to push someone into credit collections, spending $2.70 to send a certified notice is not an overly onerous burden on the company or the entity, whether it's a small mom and pop shop who doesn't necessarily have a lot of collections because they're cash or credit card or debit card. But for a hospital or a larger business, $2.70. I think the cost analysis for a letter is $5, so make it $8 cost on a bill is not that of an onerous event, and it benefits both the entity and the consumer. The consumer knows that they owe a balance, and it gives them a chance before their credit is affected to resolve the issue, and the entity that has a balance due knows whether or not the consumer still lives at that address because they get their card back. And when it comes to court, if they decide to sue the individual, if the amount is large enough for them to sue, like from a credit card company or something like that, they have a positive notification when they go to court saying, hey, we gave this guy every chance and nothing happened. So I look at it as a win-win, even though it does require somebody to do something on the collection side. With that, Mr. Chair, I'd be happy to answer any questions that the committee or people in the audience may have.
Okay, so before I take a question, I make sure I understand. So you're not looking for that the person has to actually get the certified letter. In other words, let's say the certified letter, it comes back and they say it was undeliverable. The person refused it or didn't collect it, or the post office. If you get this notice that they didn't get it, that's not your problem. You're saying they'd still be in compliance as long as they had attempted to send a certified letter.
Yes, I thought that was clear, but if not, that's fine. And it doesn't necessarily have to be a certified letter. There are entities out and about. I think there's one over in the western part of the state that actually goes out and will put a what they call a door knocker notice, like we do when we're campaigning, on your door. Only it's in a sealed envelope, so it's not publicly viewable for FDCPA requirements. But that's also possible if you have a large enough debt on, say, a mortgage or something like that, where they want to know. But yeah, the attempt needs to be made, not necessarily the successful completion of it.
Yeah, I guess the problem I got was the word affirmative, because affirmative means that you affirm that the person got it. But I read it, I see that it does not say that any actual physical affirmation has to occur. Okay.
Mr. Chair, yeah, you could probably strike out on line 3 the word give and put down shall attempt.
Yeah, something like that. Okay. All right. First up is Representative Abramson with the question. Go ahead, Max.
Oh, sorry, I was still on mute. Basically the same question as not the last time, the bill before, but these rules apply to not the consumer. It's not consumer protection. It applies to the business. So this would only apply to businesses that operate in New Hampshire, correct? Or is this different because this is, before you go to a New Hampshire court?
This would be before you go to a New Hampshire court, and it wouldn't apply to just New Hampshire businesses. It says a creditor. It doesn't say from where that creditor is located. And if an out-of-state entity doesn't comply with New Hampshire law, well, they've got no chance at all to. There's a term, I forget the name of it. Certify our results in their own local court.
Clever.
Okay, Representative Bartlett.
Chair, thank you for taking my question, Representative Ullery. So all of the bills that people get by paper don't count. So if usually you get a bill and it takes 30 days, you're supposed to pay it. Then you get another bill and it says you're 30 days overdue and you don't pay it. And then usually it takes 60 days to go to a collection. So all of the other notices don't count. Now we have to have another notice to tell the person who owes the money that it's going to go to a collection agency now. Is that correct?
That it's up to the business as to what time they want to do that. 60 days is not my experience, and being forthright, I do some what is classified as collections, but I don't touch any money at all for a couple of different entities. 90 days, they start to get worried, and 120 days is when normally this takes place. Now, if the letter goes and it's not returned, this is just a final attempt for the business to know whether or not the individual intends to do this, and it gives the business positive feedback, if you will, that this person isn't going to pay the bill. So here, I need the $50, I need the $100, I need the $10,000, or what is it, 33 cents on the dollar is a going rate. I need that money, so they just ship it over. Unfortunately, some of the larger businesses, particularly in medical billing, they don't care about the individual. They just bam, 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 next, bam, 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 next, and without even attempting to determine the situation in which the individual finds himself.
Further question may inquire.
Thank you, Mr. Chair. So I'm going to give you an example here. I got a bill yesterday from Concord Hospital, going back to a procedure that was done January 31st of 2020. And on the bill, this is my first bill for it, it has places for 30 days overdue, 60 days overdue, 90 days. So if I don't pay this bill, I'm probably going to keep getting notices. So you're saying that the deadbeat, at this point, if you're 120 days out, you're a deadbeat, still needs another notice to say that it's going to go to a collection agency, knowing that the collection agencies, if they collect, typically the business gets about 50% and the collection agency gets about 50%. Is that correct?
I don't think it's 50%. I think the business gets a little bit less than that. Sometimes
okay.
it's
Well,
60-40. Well, that's immaterial.
Yeah, that's immaterial.
Yeah,
So,
yes,
so you
in
want
effect.
another notice to go.
A final notice, an affirmative notice, something that is taking a step that is positive to the individual to assure that you're getting a bill now that's a year old. I got a bill from Southern New Hampshire that was 2 years old last week. And it turns out that bill had been referred to collection. This was just last week. I've had seniors in town say that there's what's going on. I never knew. And then they go and check their credit records and their credit score is down 10, 15, 20 points because they're a deadbeat, quote unquote, because they're referred to a credit collection company, even though they had no idea they owed the bill. Because
I have to say, I have a tough time with this one.
The 55-cent
Thank you.
letter that goes to you is a lot different than a $2.70 return receipt letter, because that one is tracked and it has to be delivered. It doesn't get burned up on the Everett Turnpike in a mail truck. Or if it does, you know that it has been burned up.
So if I get this, maybe what's confusing is the 2 weeks and the affirmative and all that. What you really want is that whenever an entity has decided to send your name and debt to collection, okay, whenever it is, could be the first month, it could be 2 years later, or whenever they want to do it, whatever they thought, that you want them to at least have put something in the mail or hung something on the door to say, by the way, we just sent you out to collection.
Or are going to send you out to collection.
No, not they're going. You want the notification. So I'm saying that you're confused. That's what gets people all worried about timing. And so you just want, whenever somebody has submitted a name, they want to be, because you're assuming that, the 2 weeks is going to give them enough time to sell it. I right now it takes 2 weeks for a letter to get in the mail to me. Okay. Cause we got all kinds of mail problems here. So you just want to make sure that if somebody's name is ever being sent to a collection agency, that there was some letter or notice or something to let them know that their name has now been sent over there.
Yeah, yes. In essence, that I would settle for that. I prefer pre-notification. But what you're talking about, Mr. Chair, would be I think, beneficial to everyone involved, particularly to a consumer who, what? I owe this bill? Here's my $10. Why are you sending it to collection? You never bothered to send me the normal arguments that come out. But yes, I agree with you, sir.
Okay. Representative Abrahamson has a question. Another question.
Thank you, Mr. Chair, and thank you for taking my question. In the middle, I'm seeing this question or the statement, no debt collector shall leave a message of debt on a recording device. I assume that means that that's not going to count as a notice, but what it just says is a standalone statement. I'm remembering, I think it was a Tom Hanks movie. Someone was calling Tom Hanks and ends up arguing with him for about a minute and then realizes that it's just an answering machine. Does that mean we're just adding this as a standalone that you can't leave a message to call back?
It's already illegal under federal law to do that.
Okay, so but then we don't need a state law on top of the federal law.
Well, there is some question as to whether or not a phone call made between two parties within the same state, whether or not the Fair Credit Debtor FDCPA applies. So yes, it was. If you want to strike it, fine. It's not that important. But that was just reminding people that they can't have a message on the public phone call, and that does not address affirmative notification, leaving a voicemail message.
Well, it's funny that you did allow them to leave a big sticker on, or post some note on the door so everybody driving by can see that, but you don't want any message on the answer.
Now, but if you notice, it also says that has to be done in a solid envelope, marked confidential, and addressed only with the customer's name.
I used to work as a merchant mariner, and you'd have a mariner out of the country for a few months at a time, and they would pick up their phone and they would have a thing where they'd call their own answering machine back home, actually have a recorded device there to try to see, are there any debt collectors or anything? So it seems like kind of a weird law that sometimes works against you.
I wouldn't know. I've never done that. I know that if you're in the merchant marine or if you're in the military services, you can't collect the debt anyway. So
yeah. Okay, so I'm going to do something which I haven't done before, but I'm going to say, is anybody in the committee room want to have a question? And just nothing else. I want to test the mics. You guys. Okay, so yeah, it's very hard to hear you guys, and let alone see you. Okay, all right, and I assume you're all set, Max, or you still have another question? I'll lower your hand. Okay. Oh, now over the attendees side, I have two other people who've raised their hand. So is that, no, I didn't have more people to testify. So, all right, well, I guess we'll just see what this means. I will start, I'm going to allow them to talk. I'm not going to actually promote him. So Rick Blaze, did you sign up to testify on this bill? Asked to unmute. Asked to unmute, talking permitted, and he's still muted. All right, so, and then, but I can't, are you?
Unmuted now.
Okay. So Rick, Blaze, are you there? Maybe not. Okay, next I have New Hampshire Landlord Association. I guess I'll allow you to talk. If you want to unmute, ask to unmute. Did you sign up? Yeah, go ahead.
Yeah, can you hear me okay?
Yes, I can.
Okay, great. Thank you for the time. My name is Mike Booney. I work closely with Nick Norman. I'm on his core team. And I'll have to apologize in advance. I've never attended one of these, but I'm filling in for Nick. As I said, I'm on his core team. So I just wanted to, we have a statement here, and I just wanted to speak real quickly on this one, if I could.
Okay, so you never did the official sign up process. Okay.
Well, I think Nick Norman, he's done this many times, and I'm sure
Well,
he did.
we're doing this the first time, so he knows that if he's done it many times, he's better than us. So this is our first day doing this. So I guess the question I would have is do you mind just having that submitted to the committee? You know, if it's a written testimony that or a written statement, you can certainly go through and have it submitted to the committee. But
yep. Nick may have done that already, but I can certainly follow up with him and make sure I have the right person, and we can get that submitted. No problem.
Okay. Because I don't know. We do have the time, but I guess my preference would be for you to just submit it because because I'm not in terms of I could promote you to have you testify, but if it's important to you that you speak, see everybody when you testify, but otherwise, if you're willing to submit it, that'd be great. All right. Yeah, go ahead.
No, I was just gonna say it's only like a paragraph. It would probably take 30 seconds, but if
Sure.
I understand
Right.
your
Sure.
time is of the essence, so we can
Well,
certainly just submit it.
we do have a little time because we have nobody else who's testifying. So if you want to go ahead and read that paragraph into the file, that's great. But you do, I guess, I don't know, Pam, can he submit his name later afterwards? So at least we know his information.
Yes, if he goes to the website on the general court website and registers today, he'll be included in the testifying list.
Okay, great. All right, so go ahead and with your testimony.
Okay. So I guess the concerns we have is by the time the bill goes into collection, the debtor is well aware of the debt. The bill is also not practical because it's making creditors give notice to debtors before referral to a collection agency when the creditor may not even know the address or location. And that's really the tough thing, is that for landlords where we have a person who leaves owing rent without notice, it's difficult, if not impossible, to even give this notice because former tenants, they oftentimes, especially if they owe money, you don't know their forwarding address. You don't even know where they went. Tenants in such circumstances, they don't leave their forwarding address. They may have moved out of state, and the collection agencies with additional resource may be able to locate a former tenant, but smaller landlords, without such resources, they may not have that ability. An enactment of this bill basically says to write off the debt by making it impossible to provide the notice. So, if you can't fulfill this notice because you don't know where they are, then you can't really, seek the debt. And I just have kind of a quick proposal, and maybe something a little different is we're all required to send a security deposit back, or at least a security deposit statement showing where their funds went. So perhaps to propose this is to say that after 30 days after they've moved out, you send
Well, I just lost you somehow. You're
and after 30 days beyond that time, if you haven't heard back from them and they've made no contact and no effort to pay the debt, then allow the landlord to hire a collection agency. That way it's a passive type law.
The clerk is not able to hear.
Yeah, I cannot hear you. You're all of a sudden, I don't know, whether your microphone or something just suddenly died out on us.
Yep. Can you hear me? Sorry.
Yes. Okay. Go ahead.
Sorry. What was the last bit you heard? The Bluetooth and went out.
Yeah, you're right. Maybe it's just best that at this point you submit your testimony to the committee and we'll look at it from there. Okay.
Okay. Thank you.
No problem. All right. So I have one other person, Stephen Tower, I guess is also in the same position. So I'm going to allow you to tell us your story and why you didn't sign up, Stephen.
I apologize, Representative Hunt. I did sign up, but I did not sign up particularly far ahead of time. I signed up at about 11 a.m. I apologize. The procedures are a little new to me as well.
Okay, so you're a Johnny come lately. So you're one of those people who we get where they put in a card even when the testimony is going on.
Yeah, I am one of those people. I apologize.
Is it possible that you could submit it in writing, or do you want to take 5 minutes and just tell us what you have to say?
I'll be faster than 5 minutes.
Okay.
I'm from New Hampshire Legal Assistance. We're a nonprofit law firm. We provide free legal representation to low-income families and seniors across the state of New Hampshire. I am testifying in support of this bill. I do think there is an important benefit to consumers to receiving notice prior to something being referred to collections. And Representative Bartlett raised a good question of, well, if they've already received notice that they owe the money, why do they need a separate notice that it's going to collections? And I think that there is an important distinction when something moves from just a debt owed to being sent to collections, because the sending of a debt to collections has a concrete negative impact on the consumer. Even if once it is sent to collections, they pay off that debt immediately to the collection company, there is a lasting impact on their FICO 8 score from that debt being referred to collections, even if they have paid it. And one of the areas of law that I work in at NHLA is I run a clinic for debtors in the Candia District Court once a month, or at least I did before the pandemic. And quite frequently, I would meet with people who said, I thought I had paid this credit card already, or I thought I had paid this medical bill, and I thought it had already been resolved. And then I got this notice from the court. I was under the impression that I had paid this. And my conversations with these people indicate that many times, had they been aware that something was going to be sent to collections that they thought had already been resolved in one way or another, they would take actions to get that resolved before going to collections. But either it is an older debt, or it is a debt that was mixed up with another debt that they had paid off, and they weren't certain of exactly where the status of the debt going to collections was. I do think there is a concrete benefit to people getting that notice before a negative action is taken. And I'll note that a very similar process to what is proposed here is done by the utilities when they are pursuing a late or unpaid utility bill. You know, when a debt is owed, they will send out a past due bill notice. But before they move to do the negative impact of the disconnect on the utility customer, they send a disconnect notice either by phone, as described here, or a posting in an envelope on a door, as is an option here. It helps provide clear notice that a substantial negative impact will happen to the customer. And I think there's a benefit to that. Beyond that, I won't say whether or not this particular bill is the most perfectly tailored means of addressing that concern. but I do think it does address that concern. Thank you.
Great. All right. Well, thank you very much. And I hope you will submit that testimony so we have it in our files for us. Okay.
I'll be happy to.
So, Jeffrey, I see that you, Representative Greason, you have your hand up. You have a question?
Yes, sir. Thank you, Mr. Chairman. And I think my question would probably be best answered by Representative Ullery.
Representative who does have his hand up. So normally I would give it, if we have the time, I would give a sponsor a final bite at the apple. So at this point, Representative Ullery, do you want to did you want to say something and take another question?
Yes, I will take a question.
Okay, go ahead.
And I have a suggestion.
Yes, go ahead. You take the question. Yes. So Representative Greason, you can ask the question to Representative.
Okay, thank you. And this goes to the statement concerning landlords trying to reach tenants that they don't have a forwarding address for. If I understand, Representative Ullery, the requirement is only that the creditor provides affirmative notification, and that can be a certified letter that they could send by mail to the last known mailing address of the, in this case, the tenant. Now, delivery is not required. So if they, and certified mail is usually not forwarded, only that the attempt was made, it is certified so that the creditor, in this case, the landlord, would have affirmative notice. I did send this notification, but that it didn't get delivered is not on me, and it's not the fault of the Postal Service. It's just, I sent it to the last known to be in compliance with this law. I sent it to the last known mailing address, and that's all that's required of me. Is that an accurate description?
Yes, and thank you for the question. That would be an accurate description. It would be a benefit to the small land owner, damn phone. It would be a benefit to the landlord, because it would give him the opportunity to say, particularly with the returning of the funds, I've made this attempt. It's documenting the attempts that are made. I would also suggest to the small landlord that there's a simple skip trace hack.
Boy, you owe lots of money to the committee now.
Yeah, well, I'm at home. I'm not in the committee room. What would happen is that if you take the envelope and if you put down on the envelope, address correction requested, you will get the new address of the person who has moved away from the house. That's just a skip trace hack that is in there. So it's just one of the ways you can find out that new address. But at any rate, to answer your question directly, Representative Greason, yes, the attempt is the key thing. And if it helps the person, as was indicated by the lawyer that spoke earlier, it's benefiting everyone, and I think it benefits both the debtor and it affects benefits the creditor.
Okay, does that answer your question, Representative Greason?
Yes, sir. Thank you.
Okay, well, put your hand down. And I have another hint of this. Rick Blaze, I see your hand is still up. Is that?
Can you hear me now?
Yes, we can.
Oh, I'm sorry about earlier today. And I did go online and register. It was easy.
Oh, good.
But I'm in opposition as a landlord. Again, it's the eviction process. When we go through a district court for an eviction notice to have the tenant removed, at the same time we get a writ of possession, we get a collection, meaning the judge basically orders the payment. So basically we already circumvented the notice process because we went through the eviction process. But from a creditor perspective, that tenant now is being told by the judge to pay, and it becomes a judgment against the tenant on their credit. So I guess this is creating a quagmire. I understand that the intent of the bill, but from a landlord's perspective, it's also becoming part of the judicial process now on the eviction notice when we go before a judge. That's all I wanted to make a recommendation.
For your testimony.
Thank
All
you.
right. I guess now I have no more hands up, so I'm gonna, hopefully we have worked this one. And so I will read the blue sheet here. And I have, make sure I have the right bill. This is 109. Yeah, good. Michael McCurry, he's a lobbyist for New England Collectors Association as opposed to the bill. Tom Ploja, Representative Ploja, is supports the bill. Ellen Scarponi is who represents Consolidated Communications, is opposed to the bill. Eric Rathbun, who is a member of the public, supports the bill. And finally, Alvin C., a member of the public, is opposed to the bill. And with that, we'll close the public hearing of House Bill 109. And we'll then go into recess until 1:15. And I guess.
Thank you, Mr. Chair.
Yeah. And thank you, Representative Uri, and you have a wonderful day.
Revenue estimates, not wonderful.
Okay. Okay. All right. So Aaron, are you still there in the committee room? No, it's lunch break. Thank you, Pam, for putting up lunch break.
Guess where we're going to lunch, John?
Okay. So is Aaron or the speaker still around?
It's just me and.
Okay. All right. That's fine. All right. All right. We'll see you all at 1:15.
Nobody ever touches anything. I was hoping that.
Hey, Chris. Hey, Connie. Hey, Joyce.
Hi.
Went for a walk. It's kind of gray down here, raw.
It's fabulous up here because there's no wind.
No, there's no wind.
Oh my God, the last 2 days have been brutal.
Look at your face.
I know.
I can tell.
And I'm hot. Ugh.
Oh, yeah.
I was cold this morning. I decided I have to dress warmer because when you just sit for a few hours, you get really cold.
Yeah, and I'm upstairs, and we don't usually heat the upstairs.
Well, me too. That's the same here.
Yeah, so I just turned up the thermostat.
Hey, Chris. Chris, say hello.
Mm.
Nope.
No.
Hey, Chris, another Chris.
Another Chris.
He's on the phone though. We got to make sure he knows how to raise his hand.
Right, we went through that. We got through it.
Oh, good. Well, I was texting him. Hey, Chris Mack.
I was emailing.
Do you know how to raise your hand?
Christy pointed it out that you go into participants and it's there.
Yeah.
I was looking just across the bottom and I couldn't find it. So
I was texting.
I thank you, Christy, for helping me out. Remember, I'm a neophyte.
Just take some practice. All of us are getting it.
Did you
Yes,
get
Joyce?
Did you get my text message?
I don't know. Which email did you send it to?
No, I sent you a text message to your phone number.
For my phone number. I'll have to check it. I didn't see. I didn't look. I'll check it.
Texted Rich to get him to mute.
I actually screwed up when he did have his hand up, and what was happening is that I have to be careful that when I look at my panelist list, that I have to keep scrolling down so that I can, as long as me and Pam are still at the top, that means I can see, because when you raise your hand, you immediately bump to the top of the list.
Yeah.
So
You need a bigger computer, John.
I got a 17-inch screen.
Yeah, how much bigger do you want?
Jeez,
Takes up a lot of desk space.
But and I do have a second.
I have a huge computer, so I can have everything on there, and it doesn't take any.
Yeah, one of those big Mac screens there.
I liked it when I was still working. We had 3 monitors, 3 screens.
Yep.
So it could move from one to another. It was great. I loved it.
Yeah.
I don't have that kind of room on my desk.
You're like a traffic controller.
Yeah, it felt that way some days.
So are we allowed to have beer during the hearing? Soda. Club soda.
Me too. I got the same.
Right.
Hope it doesn't show that.
Oh, you have to. Well, it counts it where you are. You have to. You have to pull it back.
Yeah.
And then what if your phone rings? Do you have to pay $5?
That's right.
Well, if we had a coffee fund, but I had my phone on mute, and then all of a sudden it wasn't on mute. So I must have, in my frustration throwing papers around, I must have taken the mute off the phone. So
I bet Chris McAleer doesn't know that rule.
He does now. I told him.
Well, then the fuzziness of his beard or hand.
Stapleton, yeah.
That was weird. I kept thinking, because it was so consistent, that it was like a phone thing, like a phone glitch. But in terms of,
I don't know.
But
if he has a mic right down below and he was shuffling his papers or something, it could have been something like that. I don't even know where my mic is.
I don't know how anybody can do this stuff on their phones and stuff like that.
Absolutely. How do you?
One of the important lessons I've learned over the years is that the apps on your phone are not the same apps on your computer. It's a different app.
Mm-hmm.
And so what's on your phone is stripped down. It's it's de minimis, and so I won't order things. I won't do any. I will not do them on my phone because it's just so puny and can't even see.
I think it takes practice too, because I know occasionally I'll call my son in UK, and if I catch him, if he's out somewhere, I'll pick it up on the phone, and he knows how to do it.
Well, yeah, with simple things like that is fine, I mean, I do FaceTime and I know the person's picking up on the phone, so. But
What
I-
about teachers?
ordering stuff?
Teachers have to deal with, they have to go into the school, teach the students in the school and teach the people the students that are remote at the same time. Not easy.
So Jane, that's how
Yes.
the hybrid thing works, is that they're teaching the same class, but some
Yep.
are there and some aren't?
Yes.
Oh, boy, that's nuts.
I thought it was
Yeah.
different days.
Yeah, in Manchester, the seniors went back to school yesterday. And then slowly the other, students will go in, but pre-K through second or third have been in schools all along.
Mhm.
If their parents choose to send them. Yeah.
Bartlett was closed because of COVID. We had infections.
Yeah, right. The metrics. Mhm.
Well, okay, we're almost there. So I do have an announcement to make, and that is that I have been blessed, or we have been blessed with our 2 extra days in February. So for everyone to keep in mind that we'll have full days, both Tuesday and Wednesday next week and the following week. And so that means that next Wednesday, I have scheduled where we exec those 2 bills that we heard that have to be out early.
Do you know
Wednesday,
what time about? Because I have a county meeting too.
the 3rd.
It'll be the
February
3rd at 1:15.
Oh, that's the same time as my county meeting.
I'll
I'll pick Commerce.
That county delegation have a meeting in the middle of the week like that.
I know. I'm good. I'm going to go to Commerce.
Right.
Yeah, I have a subcommittee, but not till the Friday because we won't do anything on a Friday.
I have never in my career have ever done anything on a Friday.
I was counting on that.
Yeah. No, I mean, I would always, go either side of the Tuesday, Wednesday, Thursdays. And in one year we really did have, I think you were talking about it, we had like 70, 80 bills, and I was able to just squeeze them all in there and just get it done. But the idea of, Mondays and Fridays, I mean, I'm on the my county delegation, and we're due Monday mornings, which is now conflicting with the chairman's meetings.
Right, exactly. So that's why I made this one Friday because our leadership will be on Mondays when you're having your chairs and vice chairs.
Okay, so we'll open up the public hearing on, make sure I have the right bill number. If it's Tuesday, it must be Belgium. Okay, so this is House Bill 313. Oh, this one, boy, all of a sudden my mail is blowing up under the list. Okay, so 313. So I'll ask the sponsor to raise his hand so that I can invite him to speak. There he is. Okay. And I'm now promoting to panelist, Glenn. And good afternoon and welcome to the Commerce Committee. Nice dog. Is that a lab? You're still muted, Glenn. Glenn, you can hear me, or you're muted. Can you turn your mute off? I don't know. Do I dare try to oh, there you go.
Sorry about that. I'm new to all this stuff. Thank you, Mr. Chair. Now that we can talk, I'll let you continue what you were saying.
I'm inviting you to speak and introduce your bill.
Okay. Well, I appreciate y'all taking the time to hear this bill. I think it's pretty important. There are homeowners associations that are really tough. And let me get back into what ham radio is. It's a very important thing. Some of you may know. When emergencies arise, such as Katrina, 9/11, the Boston bombings, they have to fall back on ham radio, and we have volunteers all over the country to help with that. The problem is that you have to practice this stuff in order to be good, and you have emergencies that have to come up, your batteries go dead, you gotta think on the fly and go. So the problem with some of the homeowners associations is they will not allow a single antenna. I wish I could show you, but I guess I can't. I don't know why my dog's up there, but I've got a camera here. But anyway, I've got an antenna here that's 12 inches. I've got one, some of you may remember the old, when you had your nice stereos, your Kenwoods, how you had that antenna come up and then it would tee off to the sides. I have a one here I wish I could show you. That's illegal. If they see that you've violated the rules, and all we're asking for is a reasonable accommodation. I have another one that's 80 feet long, but it connects to your house, and then you can take the other end to a tree. And with that, all you see is a piece of wire that is less than 1/8 of an inch thick, but it's 88 feet. And I mean, nobody could ever pick it up. So I just, we're trying to make a reasonable accommodation. And I would like to make one other comment before we go on is I have an amendment in the process. I'm not sure how that's all work and I haven't been emailed yet, but in the bill on section 1, part D, it says, let me get to it here. Antenna support structure means a structure such as a tower, pole, or mast used to support one or more antennas. The amendment removes the word tower. There will be no tower. Just like a flagpole can be turned into an antenna, a gutter, but we don't want a tower. So that's going to be removed. Thank you.
Okay. Do any members of the committee have a question? And Representative Bartlett, you may.
Thank you, Mr. Chair. Thanks for coming before our committee, Representative Aldrich. We had this bill a couple of years ago, and we retained it in committee, and then it was killed. One of the problems that I have with the bill is that this bill would override what a homeowners association is already agreed to for their members. And I do have a problem with that. And I mean, obviously the intent of the bill is to override what the homeowners association has already agreed to. Yes?
Believe? I don't know what you believe or.
Yes, that's true. And believe me, I'm not sure who's on there, but I am far from one to get the government involved with something. I'm more inclined to get them out. But with the importance of ham radio in emergencies, all we're asking for is a reasonable combination. Like I was trying to say, the first 2 antennas that I mentioned would be in your house, but they're illegal. They can fine you or whatever the rules they have. And I don't think that's fair. And I think that, they don't ever make the reasonable accommodations for it. And I think that they should. So as much as I hate getting government involved, I have to, for this. Plus, I didn't get a chance to look it up, but there's a federal bill that would allow the same and more, because that's how important the FCC thinks that it is. And if we get further down the line, I'll get that information for you.
Okay, Representative Van Houten.
Thank you, and thank you for taking my question. I'm looking at the first page of the bill, and I'm looking under community association, which is the definitions section. And it basically says, this is line 13, commonly known as homeowner association. Now, I live in a condo. I live in a condo association. Is there an attempt to bring all of those different umbrellas under the term community association, or is that something that will hamper your bill?
I'm not sure. Could you repeat the question for me, please?
Yeah, maybe I need to back up a step. What is the difference between a homeowners association and a condo association? Or is there a difference? Because I believe there is.
Well, I don't know that there is or there isn't. But I don't see why it shouldn't apply to both. You're asking for a reasonable accommodation for an antenna. Even some of the bigger ones can be in your attic, but under the HOA rules, they are illegal. I mean, it's very important that emergency communications exist. Cell towers, they shut them down because bombers can call in with cell phones. So it's a very important thing, and we have to be able to practice it. You just can't jump in to an emergency when you haven't been able to practice, turn your radio on, you don't know that it works. So that's the important thing, is the practice, and that's why we need a reasonable accommodation. We meant to pull that towers out of there because we all know what towers are. They're big, they're ugly. Everything that we're trying to get in this bill is minimal. It's hard to see. 1/8 of an inch wire, even though it's 88 feet. And if it's black, it blends in almost all the time. I have one that's copper, and it's tainted through the years to that green that copper gets, and it's barely noticeable. And that's what we're trying to get, is to allow people to be able to practice with something that isn't going to mess up the beauty of your neighborhood.
Follow up, please.
Yeah, follow up. So just to clarify on your previous question. So yes, this would apply to in both home, if you're, let's just say you weren't really a condo, but you had a, some kind of land, homeowners association,
Yeah.
it would apply to everybody, both of them. Go ahead with your question.
Okay, and I'm also looking here, and again, just to give you some kind of background, I'm currently in a condominium unit at this moment. There are 8 units in the building in which I am. This states that common areas such as rooftop can be used according to your bill. Would that be somewhat cumbersome if all the 8 owners of the units in my building were to do that? And would there be any kind of impact to, say, our cell service or to our internet service or any of that sort of which you're aware?
Well, I'm not really sure about the condo part, but it'd be really unique if all 8 people put an antenna up there. But they would be allowed, such as there's our antennas that are just like the dish networks. So if you have 8 of those with dish networks, or say 7 and one doesn't have it, but they have a ham radio, you still have 8 dish networks up there. Dishes.
And just to quickly follow up, if I may, I did say there are 8 units, but that means that there are more than 8 residents. And if each one of us decided to have a radio, I think the number 8 could become amplified. Thank you for your testimony and for your answer.
I guess I'd have to intervene. Is if all 8 want to do it, and they have their own owners, then they would vote to allow them all to do it. So the issue really is what happens if you have a homeowners association of 8 and you only have one homeowner who wants to do this, and the other 7 don't want them to screw holes into the roof shingles, and they don't want any antennas, or they think their antenna's ugly. And I remember the first time I ever one of those bills, it was someone who wanted to hang a flag, the U.S. flag, and he was getting flack from his neighbors. So it's the idea of that in this case, that if it's a minority, because obviously if it's the majority, then there shouldn't be a problem. Okay, next is Representative Herbert. You there, Chris? He was here.
Okay.
There he is.
I just a couple of questions, Glenn, because I'm not that conversant with ham radios, but I'm curious if an antenna is remote, not on a building, say out in the woods somewhere, but it's on common land. Would that one tower be able to be accessed by multiple ham radio guys, or is it each ham radio has a specific antenna?
Well, There, first of all, let me state, there's no towers. That's being removed. It's already been to legislative services. I called them today. But yes, everybody needs their own antenna for their own radio, just like your car needs an antenna. But like I said, they don't have to be intrusive and ugly.
No, I voted for your bill to begin with, Glenn. There was just some things that I was interested in, because we do already have towers. They're there, and I don't see why the state cannot allow, just like they allow all those individual, for cellular communication, that they wouldn't allow or in fact order a network of ham radio towers that would cover the whole state. I'm just trying to see if that's even possible.
The cell towers are one thing, but the ham radio towers, we have them. I'm vice president for the Central New Hampshire Amateur Radio Club, and we have one on Gunstock, and we have to turn it down to 19 watts instead of the 50 that it's capable of, because we were interfering with some stations. I think there were radio stations, FM, in Massachusetts.
Okay, so there's an interference problem if you start doing.
Well, we worked around that by lowering the power, but you still had, it's like a radio, and it is a frequency, just like FM 104.9. Okay, everybody's radios can tune into that, but you can't talk. With ham radio, we tune into those frequencies and we transmit as well.
Okay. Thank you.
All right, great. Thank you. Representative Terry, you're up next for a question.
Thank you, Mr. Chairman. For those members who are unfamiliar with amateur radio, or so-called ham radio, amateur radio operators are regulated by the Federal Communications Commission. So these are not individuals who are just purchasing equipment and deciding that they're going to broadcast anywhere within the country or around the world. This is highly regulated and has been for decades by the Federal Communications Commission. If I may direct a question to Representative Aldrich, did I understand you to say that there are or could be community associations that prohibit individuals from erecting antennas, no matter how small they may be, within their own residences? And if that's correct, I'm wondering on what basis, legal basis, they can regulate what you have in your own home or your own dwelling place. The second question that I have,
let me answer that
is with respect to retained 2 years ago. Did I understand that to be the case, that the bill's history was that it was retained 2 years ago? And if so, I have a question. Is that accurate?
I think it was retained, but I really don't recall the details.
Retained.
What is the history of this bill? Is it brand new, or does it have a history?
I don't have it at my fingertips. Pam, did you send out something on this one? Yeah.
It has a history. We retained it and then we killed it.
All right. So can somebody outline for me the outline of the history of this bill?
It was sent to you yesterday.
I'm sorry, I was addressing Representative Aldrich, or do I have?
Yeah, you go ahead. You're asking you're asking him for
yes.
that he.
Representative Aldrich, were you the one who sponsored this legislation previously?
Yes, I was, and I don't know if anybody is familiar with the ARRL. It's the American Radio Relay League. They helped write this bill, and I think part of the problem was we had a couple people that had testimony. I tried to find it, but I couldn't. And I think we addressed all the issues. The towers is gone, and like I said, the whole thing is they're pretty much like stealth antennas. And we are a lot different than CB. Anybody can get a CB and can talk all what they want, but we are FCC regulated. Our licenses are good for 10 years. We practice for emergencies, and a lot of the events are fun. If anybody knows what Climb to the Clouds is, I provide emergency communications for that event, as well as about 30 others. That gives us practice out in the field, and that's part of what we need to do. That's for local stuff. The antennas that I'm talking about that are really stealth are for HF. I've talked to Colombia, Germany, Poland, and around the world, and I don't even do that part of it much. I'm more for local emergencies, and that's why I started with this. And that's why I think this bill is so important, that we be able to practice when that emergency comes, that we have the done the legwork to have this just step right up and replace everything else that's gone down.
Thank you, Mr. Chairman. I was attempting to establish a baseline here with respect to the legislation, proposed legislation that we have before us, and how it may have been similar or different from the legislation that was reportedly submitted in the past, and what the objections were in the past. First, asking the sponsor, I don't want to be misunderstood, if there are colleagues who can provide additional information to me, and with your permission, I'd be happy to hear from them. Thank you.
I guess, but I'll interject here. So theoretically, someone as a chair, I'm not supposed to be telling you how I feel, or, this is supposed to be an open hearing and stuff like that. But I can tell you what the precedent was and where I was with this bill, and then you can take it for what it's worth. We have another bill coming up later, which is adding installation of solar energy systems to the roof of a house. Okay, the issue for me, it comes down to is that when someone buys into a condo or buys into a community organization, whether they know it or not, they are buying into a whole new city or town or regulated body that has a democratic process in which they're going to vote for and against things. Theoretically, if you're someone who, if you're a ham radio thing, my recommendation is that you would check it out before you bought the condo, that whether the condo is going to let you put an antenna on the roof or not. And if they're not, then that's probably not the property you want to buy into. If someone just became a ham radio later on and said, gee, I want to do ham radio now, well, it's problematic, because you got to get your neighbors, you got to get the community, you got to get people to go with it. And so in terms of this or the solar on the roof or like that, my position has always been, buyer beware when it comes to buying into a homeowners association. You're buying into a group of people, and you better make sure you've done your homework and making sure that they're okay with what you're doing. For the legislature to just unilaterally come back and say, well, notwithstanding the fact that you are a little democracy and have a little your own government, we're going to tell you what you can or can't do in terms of the rules and that, and that's where I would say in the past I have voted to down these type of bills.
So Mr. Chairman, you're citing that as one of in your perception and your recollection, that's one of the major reasons why this bill was retained and did not advance. Yes or no?
We retained it to try to work through see where there was some issues to be worked through, and at the end of the day, we ended up not voting not for future legislation.
And was the opposition extended to inside as well as outside?
The idea that you have an antenna inside your house, like for instance, I always thought, well, because a lot of them, they have a little roof, it's a roofs in space between the roof and your ceiling, that if you stuck it up in there, you'd be able to have a good signal. I don't know the nuances and all the dynamics of it, but again, it is something that you as an individual need to work out with your homeowners association, with the group, that ask the state to intervene seems inappropriate to me.
Mr. Chairman, some of us are so old here that we may remember rabbit ears on top of our black and white televisions. It would seem to me, by analogy, that the condo associations would also be prohibiting rabbit ears on top of a television set inside someone's house or bedroom. Thank you very much.
Yeah, I hear you, and that's a legitimate question. Okay, so you can put your hand down if you know. I'll put your hand down for you. Representative Ham, you're next.
Thank you. Thank you, Mr. Chair. I just wondered, and I'm quite familiar with condominium associations, and you're right. It would have to be a majority vote of all the members in the association to change the association rules. And that would only address that particular association. I'm just wondering whether, I do know cellular towers, we have 4 of them in our community, and there's about probably to be 2 more in the general area to get good communications up and down the valley. And I do know, because I'm chair of the planning board, that we cannot say no to anything that's homeland security, that enhances emergency services. We have to make provision for police and those kinds of emergency services. Now, I don't know whether amateur radios falls within that, and that maybe a regulation change. I do know it's FCC, and we're regulated by FCC also. I don't know whether, and they do provide a service in emergencies. They are recognized as an integral part of emergency services in case of any kind of a homeland security or emergency situation. So, you know, I don't know whether there needs to be FCC regulation changes. So therefore, this technology ends up on those telecommunication towers, or whether this is an important enough service that perhaps the community might provide that kind of a service. They have towers on top of their police.
What is your question? I'm sorry.
So my question is that the way to address it? It's certainly not going to get addressed on the association condominium side of things, but is it an important enough public service safety issue to perhaps justify, you know, some sort of in other places in the law?
Holy shit, dude.
Oh yeah, hey, that's Keith. You need to mute.
Oh, I'm sorry.
and Chris, you need to mute also.
Oh, and I'm sorry. I thought I.
Yeah. Okay. All right. Your question, Representative Ham, is this could be done some other way rather than forcing just homeowners associations to deal with the problem? Representative Aldridge, you want to respond to that?
Yeah, there's no way that we could like do the towers. I mean, we have what are called repeaters, and that's good for local stuff. And what a repeater basically does, it can take a 5-watt walkie-talkie radio. It sends it up to the tower. The tower transmitted at anywhere up to 50 watts. Like I said earlier, we had to back ours down on gun stock to 19 or 16 watts, so we didn't have interference. So, I mean, we're always taking this stuff into consideration. And I think it's very important to get to Representative Ham's point. If we had a 3-week ice storm or any other natural storm that we've had, we could only be faced with ham radio. And just so that you know, in Katrina, we have a relay system. So if you have a family member that was in the hurricane and you didn't hear anything, we can relay a message from one ham to the next, and it just goes on down the line. We get a message. Somebody will drive to your house and try to find you if we have to, or the police station. And then they'll relay a message all the way back up. And I can tell you that, you know, your family member's fine. We found them at the, local shelter, and everything's good. So it's very important for emergencies, and it's very important to practice. You just can't throw a kid keys to the car and expect them to operate like somebody that knows how to drive. And in order to do that, he has to have some practice. So he goes to school or his parents teach him, whatever the case may be. But I'm telling you, Mr. Chair, you especially, I understand your point of view on it. I would be the same way. I mean, I've had Liberty friends, what other things you want the government to get, and I'm like, this one is really important, or I wouldn't be doing it, believe me.
Fair enough. Thank you. You all set, Representative Ham? Okay, Representative Houghton is next.
Thank you. The upper area of I'm in a flotarial, and the northern third of my flotarial is basically condos and condo associations. And I'm always fielding questions about these. I find that many of the constituents who live here are quite territorial about associations. Therefore, my question is this: who would be the enforcement agency, and to whom would the penalty fines go?
Well, that's a good question. Unfortunately, I don't have a good answer on that one. I can certainly research it. You want to know who's going to enforce it?
Well, in the legislation, it does indicate charges or penalties that are assessed. And I don't know if the association, the condo association, would be the enforcement agency, or if this falls into some kind of departmental element of legislation. And who collects the money and who keeps the money is the other part of that question.
They would have to, the homeowners association would have to take that homeowner to court.
It does, may I follow up? It does say that there are charges or penalties that precede any kind of court action.
So what, yeah, I'm not a lawyer, nor do I pretend to be one. So
it might be a missing element of this bill.
Deeds, and if you're trying to sue somebody for deeds, so the statute is under, one person would take the other person to court. So
right, but again, there is that step before going to court, which involves charges and penalties. And I just want to know whose purview that is, who handles that, who keeps the money.
Maybe that's why we retained it the last.
Okay. All right. Thank you.
Know the answer to that question.
And thank you, Representative.
All right, Representative Abel, you're next.
Yes, thank you, and thank you for your testimony today. Representative Aldrich, I believe you said that you were either the prime sponsor or one of the co-sponsors of this bill when it came before us in earlier sessions. Is that correct?
Yes, it is. We knew there were some issues, so we reworked it. It's not the same bill. And like I said, so far, the only part that I've seen as wrong is that, the towers will not be there. That word will be removed. And as soon as I get I don't know if they'll send it to you guys or to me or what, but I called and made that request this morning when I saw it.
Follow up, please.
Further question, may inquire.
Thank you. As I recall, then the earlier bill, and I somehow think it came before us twice, was that the earlier bill did include towers that were pretty tall, maybe 100 feet or more, and that most of the objection, as I recall, was to that. So this would be a different bill because it doesn't have that. And I don't recall there being, I'm sorry, I will get to my question.
I hope so.
Okay. I don't recall there being discussion of interior antennas that were not visible outside of the homeowner's property. So that would be something we would need to look into, that, would we not?
That would be to narrow it down to something that nobody else can see that's inside your unit. I would venture to say you probably can do that now with no problems, because nobody else in the homeowners association will know you have one. So,
well, that's not entirely true. If for some reason they needed to come in and see it, it's against the rules. And to get back to those rules real quick, all those were pretty much cookie cutter. Somebody came up with it and they pretty much use the same thing. I live in a mobile home park and a co-op, And all the co-ops, they almost always do the same thing. So then we have to go to our rules committee and change them individually, but they try to come in and do them. And the homeowners associations do not like changing the rules like the people, that actually own the co-op.
So do you have any anecdotal story in which a homeowners association actually enforced this and prohibited hams for someone who had an antenna inside their house?
I don't, but I can certainly look for that.
I would hope so, because like I say, I'm hard pressed to believe that there's ever that if any homeowner association, in terms of what we've seen, the rules are usually because you built something on the outside of the building and put it on the roof or the siding. I mean, we had one bill, the guy he had a snow blow. He was snow blowing his backyard so his dog would have a place to go. And the homeowners association, the condo association, cracked down on him because they said you're not allowed to snow blow on your lawn, but other on their lawn, which is obviously community owned. So I guess if I would be, at least for myself personally, might feel a little bit different if you could show me that actual homeowners association was so anti-ham that they would not even allow you to have an antenna inside your house. If you could find one of those stories, I'd be interested in it. So I don't see, Representative Greason, sorry.
No, thank you, Chairman, and thank you, Representative Aldrich. I think what I'm hearing is a misunderstanding on, maybe not amongst everyone here today, but maybe amongst the public and especially the homeowners associations, of the type of equipment that might be installed, the types of antennas that would be installed. I think they have this picture in their mind, those unsightly antennas, aerial antennas like we had back in the day. And I think that's what or the small satellite, or even the huge satellite dishes that megaton satellite antennas. So just, could you describe the type of equipment, antennas or whatever that could possibly be installed on the outside of the house that would be considered, quote, unsightly, that is usually in the aesthetics of a homeowners association, that would be the source of the objection? How is this different from those aerials from the 70s?
Well, they're mostly towers. For example, the thin wire I was telling you about, that can be dropped in a gutter. It could be hung from a balcony. It can go from your balcony, like I said, a piece of just electric wire, less than 1/8 of an inch, that's 80 to 160 feet, can just go from your place to a tree and hardly ever be seen. They have flagpole antennas that tune up to certain frequencies on there. Did I miss one of your questions on that?
No, it seemed like, is it?
No, all I'm just getting at was the fact that I think that there's just a misunderstanding of the actual type of equipment. Having lived in a homeowners association before, everything is seems to be about aesthetics, and aerial antennas and satellite dishes are big no-nos, that and the color of your house. And so,
I'm sorry.
Well, I just, if you can, being able to express the exact type of equipment that would be installed, I think is why they would. I think that's what they have in mind, and so that's why there are these objections. It's just ignorance on their part. So.
Well, like the DirecTV, those dishes, I don't know. I think they're kind of small compared to the other ones. They can actually be used for that, and I don't think homeowners associations bar them, do they?
Again, it's really any individual association, what they had decided and what they put in there. Based upon what you just described to me, I could see some association not liking a 100-foot wire stringing from the side of the building to a tree. Because that's just like the guy who was snow plowing the path for his dog. that I can see an association having an issue with just a wire. Yeah, because it's anything exterior. Because I think Representative Greason's hit it right on the nail. It's aesthetics, and unfortunately, if you get into a homeowners association, you have to know that some homeowners are very particular about what they think the aesthetics of their outside of their building are, to not only to the color, what you're painting, or what type of shingle they have on the roof. I mean, they can get really picayune about it. So I assume that's maybe what the issue is, but I don't know.
Well, that was just one. Like I said, you can drop that same wire in a gutter, and depending on how long your gutters are, you can tune that up too. I mean, I probably shouldn't have thrown that wire in, except for it is so small.
I guess you'll have to give us an example. We probably need some more anecdotal, anecdotal stories to what's going on in New Hampshire.
Have you? How about
actually exists?
How about, just for an idea, an extension cord? They're like the cheap brown ones. They're connected.
Yeah, but they might have rules about Christmas lights, and say,
okay, well, it's one of those. That's the thickness, and actually, it's thinner than that. Then if you cut that in half and had the two pieces, it's smaller than that.
Okay, I think we get it. Okay. All right. Are you all set, Jeff? Representative Greason, you all set?
I'm all set, thanks. I'm familiar with amateur radio with numerous friends who are involved, so I know all the equipment that they use and that sort of thing. So
yeah, okay.
I've also been a homeowners association, so I know all about those too. So.
Okay, Representative Bartlett, you're next.
Thank you. I'm sorry, but I guess I have to go back to the flagpole type tower. So are you saying that if I live in a homeowners association, we paid for underground utilities, but if this bill goes through, you can put out a flagpole with 180 feet, whatever, of wire to this flagpole?
No.
And this bill would force the homeowner association to accept it?
No, ma'am. If your homeowners association doesn't object to having a flagpole, and you would have to probably go to your town and make sure if you had, certainly to the homeowners association, then probably to the town, because if you're going to put a flagpole in, you're going to have to be digging in that dirt. So as long as there's no objection for that, you would probably have to get a permit. You'd have to certainly get the homeowners association approval, but it's just a standard looking standalone flagpole that has a wire running up the shaft and could be brought into underground or along the ground, depending on how close it was to your house, where you would never even know it was anything other than a flagpole. So there's nothing attached to it except a flag on the outside.
Okay, thank you.
Okay, so we do have other people testimony, but I do see some more hands up. I assume you're all set, Chrissy. Joyce, did you have a question for Representative Aldridge?
Yeah, I don't want to belabor this, but thank you for letting me just express one thing. I hear that Representative Aldrich, you're really trying to make it seem as though this is not objectionable. But in your bill on page 2, lines 13 through 16, you talk about electrical enclosures, ground mounted control enclosures, and guide wire anchors that have to be screened. And if they're visible from the street. And this sounds a little bit like more than just a wire. What are we talking about screening here?
That, I'm sorry for that. I'll have to get another amendment. Any guide wires would be going to towers, which we took out. I just didn't catch that part, but thank you for me, and I'll correct that.
Okay, thank you.
Thank you.
So like I said, we have some more people who would like to speak. So Representative Terry, you just heard a question, Reverend?
Just 1 minute.
Yep. Okay.
If that. Thank you, Mr. Chairman. Representative Aldrich, as someone who's familiar with amateur radio, I can see that there are members that are struggling today visually. They're trying to picture this. So would you forward to the chairman maybe 3 or 4 or 5 photographs that would be expressive visually of what you have in mind in terms of what the bill would permit or require to be permitted? I think that would be enormously helpful if we could have everybody see exactly what you have in your mind right now. Thank you.
That would be no problem. I don't know what's going on. I don't know why my dog's up here, but I can see myself to the right.
You have to go down to your video and change your video settings.
Yeah, well, I was afraid I'd lose you guys, but if we can get towards the end, I
think
can.
if you can, send to the committee some photos of what you're thinking about. That would be helpful. I think it's
I certainly will. I could show you right now. I have them right here, but I'll send them. Sure, thank you.
That'd be great. Thank you. And Les, Representative Van Houten, did you want to do this again, or you want to wait till we get some other people?
No, I just want to make sure that I have a clarification of something that I referred to earlier. I live in a condo, 8 units. I live on the lower floor. There's a floor above me. If the gentleman above me had an antenna of this sort up for his amateur radio, is there any chance that there would be any interference to my cell phone, to my cable, to my internet, to any of that sort, or would I be free of that possibility of interference?
Well, the only time that the FCC is very clear, anytime there's any interference like that, you have to shut down immediately and then try to find the cause. And if you can't ascertain what it is, then you cannot fire it back up. So no, there will be no interference for any of that stuff, cell phones. The only time anything like that would even probably most likely be and remotely happen is if somebody had like 1,000, 2,000 watt power, and most of us run 100 or less. So there's been no issues with that.
Thank you.
Great, thank you very much. So now, Representative Ohm is, I've just moved you over to the panelists, so you're free to welcome to the Commerce Committee.
Thank you, Chairman Hunt and the members of the committee. Appreciate your time with the issue here. I want to make 2 points. One is that I live here at a condo in New Hampshire, and I have my antenna totally confined to my limited common elements. It's all on my back porch. It looks like a bird feeder. My neighbors are curious, what's that? It's part of my weather station, but I also use it for radio, which is true. So I think one compromise you might consider if we get stuck on the outside effects of the antennas is to say, let's keep it to the limited common elements of the property. It's on your back porch, and it's only on your back porch. It can't go anywhere else in the building, anywhere else outside of the building. But I did want to talk on the second point anecdotally about the value of having trained radio operators available for public service and public safety. And I'll speak to the 2013 Boston Marathon. I served for about 20 years as a radio operator for the Boston Marathon. In 2013, I was assigned to dispatch. Dispatch means I've had about half a dozen Red Cross stations and some water stations. At the Red Cross stations, I have one person who's assigned to the station chief, always be in their sight. Another person looking at the school bus pickup points for runners becoming exhausted to the point they can't continue anymore. Where do they go? We direct them to the school bus pickup point. Then I have a third operator who's a floater. His job is to make sure that everybody else is doing their job, and he's got his eyes and ears out looking for problems. Typically, we see runners going down the course with distress. We had a call from a station up the course saying runner bib number so-and-so appears to be in distress. We'll advise our station chief of a runner that needs to be monitored. We'll pass that along, and if necessary, call for an ambulance. In 2013, typical marathon runner race, TV was on for a few hours. They show runners going up Heartbreak Hill, do some anecdotal interviews, and they shut it down and go to daytime programming. But now we're busy because most of the runners are not elite runners. Most of the runners are pretty good runners, but they get tired. And we get a lot of calls from the medical stations to get supplies, get treatments, and sometimes call for an ambulance. In 2013, we got a call from our station cruise chief that go silent. There's been 2 bombs that went off in Boston. Don't say anything on the air, but be ready. And then we get our instructions. The instructions are stop the runners at the Red Cross station. And we explain that to the crew chief, who probably knows it already, but we're there to help direct traffic, look for problems, and assist. So in my sector, the runners were then assigned to the Newton City Hall, where there's school buses to pick them up and take them to the next point from there. But the important point of the training here is that you need to have experience passing traffic back and forth about situations in a clear manner, concise, and to the people who need to know. And having a radio station at your house gives you that training. Doesn't have to be elaborate, but you need to be able to run drills where you have to understand what's being talked about, which is complicated information, copy it clearly, mark it down, and send that in as a report. These are called some of our contests. But there's a lot of intense activity to do this training and report accurately. So I hope the committee will support the bill in the context of adding amateur radio operators to the balance of public safety people as backup. We're not the primary communications, but we're the backup communications. So when things go bad, there's people available to pass traffic and to respond properly if they're called up. Thank you, Mr. Chairman.
Great, thank you. Does anybody have a questions? Okay, Connie, Representative Van Houten, you have a question?
Yes, thank you, Mr. Chair, and thank you, Representative. Please excuse my ignorance, and I really know very little about this. Are most amateur radio operators involved in networks of the type that you're talking about, or is that something that happens sporadically in terms of community need?
Yeah, we're actually called the Amateur Radio Service. So the basis of getting your license is for service. There's many ways to do that. Some people do experiments with new technologies, digital modes of communications. Many operate in local public service events like I've been doing. It's a wealth of opportunities.
Thank you. Quick follow-up.
Further question, may inquire.
Are there many people involved in these types of activities, or is it just a small minority?
Oh, quite a lot. Boston Marathon, we have 200 to 300 amateur radio operators. We have them at the finish line, where they were very busy in 2013 because the cell towers were shut down. As was pointed out, when there's a pending problem and there's perhaps radio-controlled bombs, cell towers go down. Need backup communications. We were part of that system. There's certainly private radios that were used, but we were part of that backup. At the beginning of the course, there's a whole nother activity going on, mustering of all the runners, separate whole project. They're up most of the night, but they go home early. And then most of the people like myself are in the middle of the course between the initial rounding up of the runners, the start of the races with the wheelchairs, and then the elite runners, and then the regular runners that last till about 5 o'clock at night. We're in there for about 12 hours.
Thank you. Thank you for indulging me. I really didn't know much about it. Thank you.
Representative McClear, do you have a question?
Yeah, I don't mean to show my ignorance, but I'm familiar with marine radio, which is obviously portable. I always thought of ham radio as being a single station and not mobile, but the way you're talking, it sounds like you're mobile.
Yeah, it ranges from the handheld walkie-talkies to a mobile station in your car to a home station that we're talking about in this bill today.
It's a broad band. So, okay. Thank you very much, Bill. It's nice to see you again. And so next, I'll ask, let's see, who, Bob Betts. If you there, raise your hand. I don't see a hand raised. Bob Betts, are you around? Next is Fred Hoppengarter. Didn't I see that guy, the name? Fred. Yeah, Fred, would you like to speak? Okay, good. Thank you. I will promote Fred to speaking. And welcome, you're still muted. Welcome to the Commerce Committee. Yeah.
Thank you very much, Chairman Hunt. I wanted to say a few things and be very brief. The opposition that you will hear to this kind of a bill is that these antennas are unnecessary, but you've heard from Representative Ohm that without outdoor antennas, you often have no useful ham radio. You'll hear that these antennas can be unappealing, but basically we're trying to design a bill here where these are virtually invisible antennas, or they are identical to antennas that are already permitted under federal law, like a TV broadcast antenna, satellite, the tiny satellite dish antenna, or a flagpole. In fact, CAI, the Condominium Association Institute, is in favor of flagpoles. And we can use a flagpole as an antenna without a need for wires from it. You run a feed line to it underground, you load the antenna, that is the flagpole, is the antenna. And you will hear that some of this may not even be desirable, but I suggest to you that for New Hampshire, it would provide a training ground for not only emergency skills, but also technology skills. There's one other thing I'd like to say briefly, and that is, can the association vote to allow the antennas? Sadly, frequently, that's impossible because the prohibition on any amateur radio antenna may be included within the common covenants and restraints that run with the land. It may be impossible to change that covenant unless perhaps you get not just a majority vote, but unanimous vote. Frankly, you're looking at something that's impossible there because you may not be able to even get to some of the people who have the vote. Finally, I'll tell you that the kinds of antennas we have proposed in this bill, and if we've miswritten it, I'd be delighted to rewrite it. I'm the guy who typed it out, and I'm learning things all the time from members of the committee, are antennas that are already permitted by federal law for satellite TV or other broadcast or wireless internet reception. We're not looking for different kind of antennas. We're only looking for permission to use those kinds of antennas for ham radio. A wire, minimally visible wire. If you wanted to limit it to a backyard, I'd be happy to work with people on writing that. It suggests antennas raised only in darkness, and unless somebody can see in the dark, there is no aesthetic problem there. And antennas perhaps no higher than a roof line and in the backyard that cannot be seen from the street. And finally, the flagpoles that are already allowed by federal law, but to be used by amateur radio. In other words, what we're trying to do here is meet every objection we hear. And I hope the committee will consider this bill favorably or work with us to redesign it.
Okay, is there any questions from the committee? And I would correct one thing. We did have this issue many, many years ago that when it comes to condo association agreements that were written in the original deeds, that it is an 80% vote, that it does not require to be unanimous. We did change that for one circumstance, and then I think it was changed again. But so I think that that's somewhat a little looser, but again, it does require a very super majority. Okay, I see no more hands raised. Thank you very much. And I have one more hand that's raised. It's Gary Daddario, which I don't have you, Gary, on my list at all. So I guess what I'd like to do is just, I'm going to allow you to talk. So did you want to sign up for it and didn't have a chance to speak, and who do you represent? And there we go. You can speak now, Gary.
Okay, thank you. And I apologize for not being signed up in advance. I didn't realize. I thought we just needed to get on Zoom. I will try to be brief. I am an attorney and I partner with Marcus Rico, Emmer & Brooks. My office is in Merrimack, New Hampshire. I'm actually speaking in my role as the chairperson of the Legislative Action Committee of the Community Associations Institute, which was referenced previously. Speaking bluntly, I have to say, this bill appears to not just infringe upon association rights, but really to rather trample them. I mean, I'm looking at the language in here, and not only are they setting aside or seeking to set aside covenants and restrictions that are already on property, and I've heard this discussion already and commentary from several people that no one has to live in these associations. People make a voluntary decision to do so. And when they do that, they're agreeing to live by these restrictions, but this bill would set those aside. And it would do it in favor of the hobbyist, regardless of the opinion of the rest of the community. I also see in here language that says that the unit owner would not need prior approval before installing some of this equipment. That speaks against associations in general, because they all have a requirement for approval, even where people have a right to install something. It's about the association knowing what's going on and knowing that it's being done properly. I see language in here that says that someone wouldn't be prohibited from using the common areas, including the roof, for the installation of this equipment. And for those who aren't particularly familiar with associations, when you have the unit, and that's under the ownership of the unit owner, and you have common areas, please know that the common areas are not owned by a particular unit owner. And so what this bill is also doing is it's raising both constitutional and property rights issues and questions that would be very problematic, because to my knowledge, there doesn't exist another scheme within which any of us have the ability to install any type of equipment on property that we don't actually own. And there are going to be some serious issues that could come into play when people start drilling holes into roofs, and then the roofs start leaking, and then you have unit owners suffering water damage who are other than the people who put the antenna there in the first place. And I think these are the important questions that sort of speak to why this isn't good for associations. And I think that really is the question that this bill needs to look at, or that the committee needs to look at when reviewing this bill. It's not a question of the value of ham radio. I don't think any of us would argue against it being a valuable activity that people engage in that's helpful at times. I think the issue here is a question of property rights. What this bill is dealing with is the places where people would be able to conduct this activity and install this equipment without restriction. And unfortunately, when it comes to associations that already have restrictions on record, it seems inappropriate for the legislature to step in to try to set that aside. Towards the end of this bill, we see language. This gets back to my point about where it's really a trampling of the rights of the association. Towards the end of the bill, we see language about what the fines will be. I've never seen requirements of what association fines would be for violations of anything other than in their own documents. So really problematic stuff here. Also, if there's a place where the committee would like me to send it, I'm happy to send 2 documents that I've obtained from CAI's national organizational branch. They were involved with a proceeding that dealt with this issue before the FCC. And the documents that I've looked at from them indicate that this bill has been proposed on a federal level, and it's been proposed and rejected multiple times. In that this bill, as sort of another strategic avenue, has been proposed to the FCC, with the idea being that the FCC would make a rule that would preempt the covenants and restrictions on association property, and multiple times that has also failed. And so what you are being asked to do with this bill is, as the New Hampshire State Legislature, to make a mistake, commit an error that nobody else has been willing to do, not the federal legislature and not the FCC. And so I think it's really kind of a big ask for you and a bit of an unfair ask as well. And like I say, I'm happy to send this information
Yeah,
along.
so Gary, what you do is if go onto the state webpage, the House Representative webpage, and sign yourself up, and in there will be a field for you to upload your testimony and anything else that you want us to see.
Thank you.
Yeah, thank you. And then I have Dean Lennon, who also in the same position. So I'm going to click on you to allow you to talk, Dean, but I'm not going to upgrade you because.
Thank you, Representative Hunt. Can you hear me?
Yes, we can. Thank you.
Excellent. I appreciate the opportunity to speak. I am also an attorney at the same firm as Gary. We are law partners, and I'm also on the New Hampshire Legislative Action Committee as part of CEAI New England. I don't want to reiterate any of the points Gary made, although I certainly support everything he said. I think the way to look at this is that when someone moves into a community association, they have certain expectations. They know there's guidelines for the appearance of property, for rules and regulations that they must abide by. And what this bill seeks to do is to undo all of that and give certain people who engage in a certain hobby rights that trump all the rights under the governing documents. Owners are given the right to use common area for their own purpose, whether or not the board agrees with that, and gives that owner rights that are superior to other owners at the condominium. It sort of flips condominium living on its head, if you will, because instead of the board being in control, it's a single unit owner. I think there are serious constitutional issues with the bill. I think there's property taking issues when you're allowing an owner to acquire common area for his or her own use. And I think you are vitiating the condo docs as a private contract. You're changing the terms of these pre-existing private contracts between unit owners at the condominium. For example, under the proposed statute, an antenna up to 33 feet high can be installed without prior approval. I think that would be upsetting to the great majority of most any condo community if suddenly an owner installed that without prior approval. The statute also says that if an owner installs an antenna on limited common area, the board would have mere easement rights to fix limited common area if it had to be done. So instead of the condo association owning the limited common area because it is common area, all of a sudden they only have easement rights because this limited common area has been used to house an antenna. So I think it really does trample the rights of condo associations and upends all the expectations one has about living in a community association. And for all those reasons and the reasons stated by Gary, I vigorously oppose this bill.
Okay, so and similar, please go online and log in and register, and also if you can put your testimony in form, that would be great to have that on file for us.
I would be happy to.
Thank you very much. Okay, now I see no more hands, and so we are definitely past our time. I would read the blue list, but it blew up my printer. So there's probably 100 names on here. Not that I knew any of the names, but I assume that these people were probably all ham radio operators, but maybe not. I don't know. This list will be uploaded. It will be in the file. So if you folks want to see who all these people who weighed in in support of the bill. So with that, I will close the public hearing on House Bill 313.
Thank you, Mr. Chair.
Yeah, thank you. All right. So we're a little late here, right? Now so we're behind schedule now. Oh my God. All right. All right, so next is, we're going to go to the House Bill 166, relative safety requirements for pools on foreclosed residential properties. And I'll ask the sponsor to raise your hand, or anybody else who wants to speak on this bill. And there's Pat. All right, perfect. All right, Representative Brahmi, I am now moving you to the panelist, and you are now recognized to speak. Good afternoon, Representative Brahmi.
Chairman, for the record, State Rep. Pat Abrami, Rockingham 19, Town of Stratham.
Can you speak a little louder?
I know for some reason, I was having problem in Ways and Means a little bit ago about this. So can you hear me a little better now? I'll just speak closer to the.
It's very low, so speak.
Right, I'm going to have to
be assertive.
All right, I apologize for that. I'm here to introduce House Bill 166 relative to safety requirements for pools on foreclosed property. It's a simple bill which requires the pool cover be placed over a pool of a foreclosed residential property unoccupied for 60 days or more. This is a bill that was filed last year. The bill came out of committee with overwhelming support, and it passed on the floor on a voice vote with no debate on the bill. Then when it went over to the Senate, it was not heard, and there was no hearing, and it was tabled along with hundreds of other bills that met the same demise last year. So I refiled it. Last year, I had the backing of the New Hampshire Bankers Association, Ryan Hale, who's their government affairs person. And I did reach out to Ryan. Hopefully he's on the list. I don't know. I don't have access to, I can't see the participant list from here. And he actually helped me amend the bill a little bit. The last line of the bill says, this requirement shall not apply to any surface waters on the property, including but not limited to watercourses, lakes, ponds, marshes, or tidal waters. He just wanted that assurance, and the Bankers Association supported the bill then. I filed this bill at the request of Luke Pickett, my constituent from Stratham, who's in the real estate business. Mr. Pickett should be on the list.
Yes, he is.
To speak. Okay, great. And I suggest, Mr. Chair, that you hear from him next. And to spare you all me answering questions that he would probably do a better job of answering and catch up on time, unless Mr. Chair, you have a pressing question of me. I'm also in Ways and Means at the moment on Zoom.
Right.
I mean,
So
Chair, if you want a question or two of me, I'll take it, but it'll be redundant of what Mr. Pickett would say, but
okay,
it's up to you.
Just to make sure I remember, this bill did not come to Commerce and went to.
It must have gone to another, I think it went to Judiciary.
Judiciary is my understanding.
Yeah.
Representative Burrows is from that committee, so she probably remembers the issue. Right. Okay. So, all right. Well, thank you very much, and go back. And,
I guess the only thing I'll say is that for properties that were mortgaged, Freddie and Fannie requires this type of requirement. And you'll hear that from Mr. Pickett.
Great.
Okay.
All right. Thank you.
Thank you.
All right. So, Mr. Pickett, you have been promoted to a panelist. So all you have to do is unmute, and there you've done that. So, good afternoon.
Good afternoon. Can you hear me okay?
Yes, we can.
Thank you for letting me attend. As Pat said, we came before, I guess it was the Judiciary Committee, not sure why it was, but last year, and presented this. In essence, it's an attempt to eliminate an attractive nuisance in neighborhoods and communities where an unattended, unoccupied home has a pool out back that, as I think anybody can imagine unattended or unoccupied residents tend to be attractive to kids, and uncovered pools, either uncovered or unnetted pools, can be extremely dangerous, especially at night. As Pat said, this is required by certain lenders. We approached the Bankers Association last year, and they fully supported it. I was very pleased with that. I have both a bank background and am currently a real estate agent, primarily on the commercial side, but understand this being an issue on the residential side as well. So again, it is a practical, simple attempt for lenders to protect communities and neighborhoods from an unnecessary attractive nuisance for kids.
Great, thank you. Is there any member who wants to ask a question? I guess not. I guess it's straightforward enough. Anybody in the committee room? I forget to ask them. Not that I can see you, but it's all right. All right. Well, thank you very much. I guess we're all set. And I have promoted William McKinney.
Thank you.
Thank you for testifying. I've promoted William McKinney to the panelist, and you are free to testify, Mr. McKinney.
Yes, good afternoon, Chairman Hunt. I appreciate you hearing me today. I'm William McKinney. I'm the president of New Hampshire Building Officials Association. And at this current time, we have no position on this bill, but I do have 4 questions if we could get some answers to that would help us come to a position on this bill. We weren't familiar with it in legislation last year, but it did come up on our list to watch this year. If you're unfamiliar with New Hampshire Building Officials Association, we are primarily an education association, professional association for code officials, building, fire, licensed design professionals and contractors, and educating them on code, building and fire code, and zoning ordinances in the state of New Hampshire. The 4 questions, if I may, Mr. Chairman, are: first off, we're concerned with, and we don't understand what the purpose of the pool covers are, and what issue are we trying to correct? Would you like me to do all 4 questions now?
Sure. Why don't you do the 4 questions? The problem is you're posing them to us, and just theoretically we would be asking the sponsor to do this. So Luke, I know you're still there and muted, which is appreciated. So what I would ask is that you've posed your 4 questions, and then we can have Luke come back and respond to them.
Thank you very much, Mr. Chairman. Our second question is, who is expected to enforce the pool cover requirement? That's a big concern from the code officials in the state. Third question is, who is responsible for tracking of the foreclosures and making sure that the pool covers are installed? And our fourth question is, there's already requirements for pool protection requiring guards and barriers for pools already in place in RSA 155A, and specifically the International Spa and Pool Code, section 305. And we're just concerned, we just want to make sure that we're not having conflicts between something that's already in legislation now and what's proposed in this legislation.
So I would actually guess that that fourth question really goes back to your first question: is where's the problem? What's exactly the problem trying to solve? If we already have a it's a building code requirement that all swimming pools have to have a fence around them anyways.
Correct. Yes, sir.
Perfect. Okay. Mr. Pickett, would you like to respond to those questions?
Yes. So I guess first and four are somewhat related. The purpose of the pool cover is to actual pool cover or pool net is to actually cover the pool itself. Fences are typically not barriers to entry, especially when a home is unattended or unoccupied. When I was a teenager, we used to refer to it as pool hopping, and it was really fence hopping. All fences have always been in place, and they're not new, but they are not a significant barrier to problems. The purpose of the pool cover or pool net is to actually secure the surface of the pool itself, whether it be full or empty. Even an empty pool is dangerous because people can fall in, hit their head, and with just a little bit of water at the bottom could also be an issue. So it's actually to secure.
I hate to say this to you, but you really need to keep straight, because every time you turn sideways, we lose you. So
I'm sorry.
So your microphone is very centered on you.
Okay. Who is expected to enforce it? I would not really thought about that, but it would be, to me, it would be logical to have that enforcement be local, just as while an occupied home is required to have a fence, whoever would recognize or observe locally whether a pool has a fence on it would also be the individual or group responsible for identifying whether a foreclosed home has a pool cover or pool net on it. And then in terms of tracking, I believe when a home is foreclosed upon, title changes, and the taxing authority is noticed when that title change occurs, and therefore the local municipality, and I would imagine the local enforcement, are housed in the same building. So I think that change of ownership would be triggered locally, or would be identified locally as well.
Which sounds like code enforcement, the town's code enforcer should.
That would be my logic. That's where I would see it as logically landing. Yes, sir.
Okay, great. Okay, now I know this is a little awkward because I had somebody else asking the question. So, in terms of our code enforcer, did you have any other questions to be asked, or is everybody, you okay with that, or did he take him? Oh, you know what? I might have pulled him out. So raise your hand again. I'm sorry. Up your hand back up if you would like, if you have any more questions. Otherwise, we'll assume we're all set. Okay. All right. So we have, I guess we're all set. Do I have anybody else? So thank you very much, Mr. Pickett, and Bill McKinney did respond, or did get questions. He got his questions answered. So is there anybody else who would like to ask questions?
Are you able to hear me, Mr.
There
Chair?
you are. There you are. Okay.
Yes, there's a problem with my microphone, I believe.
Okay. Well, in this case, they needed you to raise your hand, but I probably didn't say that. But okay, go
I'm sorry.
ahead. No, that wrong hand. It's that little yellow hand.
My raised handing disappeared on me too. I'm having all kinds of problems today.
Okay. Okay.
So
all right.
Yeah, I would actually, request that, possibly the sponsor of this bill and myself can have a conversation on this after the meeting, just to address a couple of concerns that we're going to have.
Urge you to do that. Yes, that would be wonderful. I do. Please, thank you. We appreciate it.
Excellent. Thank you.
So that's great. Okay, now anybody else who would like to raise their hand or weigh in on this piece of legislation? Okay, good. On the public hearing, on the blue sheet, we had Eric Rathman, who supports the bill, and then of course Ryan Hale, who was mentioned before, the New Hampshire Bankers Association, also in support of the bill. And with that, we'll close the public hearing on House Bill 166, and thank you all for your testimony. Now, how are we doing for time? 2:30. So we're all right. So we're almost caught up. And so I guess I would ask the sponsors of 473 to raise their hands so that I can then. Okay, there we go. And Representative Jenigan. Okay, so I'm going to have you promoted to panelist. There you go. Good afternoon, Representative Jenigan.
There we go.
There we go.
Thank you, Mr. Chairman. I'm, for the record, I'm Representative John Janigian, Rockingham District 8, Salem, New Hampshire. Today, I want to introduce HB 473, which establishes a renter's insurance notification requirement. With this bill, I introduced last time in a different bill number, made a couple of changes. I'll explain the reason for it, and then I'll tell you what the minor changes are that might make it more palatable. This bill basically requires a landlord of a residential rental property that is rented for a duration of longer than 1 month to include within the rental agreement just a simple sentence or two that informs the tenant that the landlord's insurance does not cover, that's the landlord's property insurance, does not cover the tenant's belongings from loss or damage, and that the landlord recommends the tenant, they don't have to, but the tenant purchase their own insurance at their own cost. What is the point to this bill? Well, the major point to it is, and I've been a landlord, by the way, for over 30 years, I've noticed that probably at least half the tenants coming in have no idea about renter's insurance. They just figure, well, if something happens, the landlord's, I don't know if they even think about it. And it's typically younger tenants that would fall into this category, maybe first-time tenants and younger tenants. But there's many instances where a tenant's property has been damaged and they lose everything and there's no way they can recover it if they don't have insurance. And sometimes it can end up in landlord-tenant disputes where the tenant is mad or upset that why didn't the landlord tell them, or why isn't it covered, or whatever. So this tries to help set that expectation and to minimize the issues in that realm. There's also, I mean, I can't see the list, but there's at least one other person, Diane Paquette, who will be talking, I believe, from Salem, and she's helped several fire. We had a couple of major fires in Salem where many tenants lost their belongings, and none of them had insurance. So it is something that would really help. A lot of landlords probably already have a sentence like this in, but many landlords still do not. And one of the things that makes this simpler than last time is there was two concerns that I remember last time. One was landlords were worried that they'd have to go back and fix all the previous rental agreements. So this HB 473 explicitly says it's only required for new rental agreements going forward and written rental agreements. Because I also had some people who were worried, well, what if you have tenant situations where there's oral agreements, maybe someone's renting a room in a house and things like this. So we take all that off the table too, and tried to simplify this to the point where hopefully it's palatable. And, obviously if there's any other changes, I'm open to other changes as well. But with that, I'll stop talking. And if anyone has any questions for me, I'll try to answer them to the best of my knowledge.
Great. Representative Van Houten.
Thank you, Mr. Chair, and thank you, Representative. I remember some heart-wrenching testimony last session by people who lost everything. And we all know that people can lose more than everything. They can lose life as well. So this is an important issue. And I am a former, by the way, Mr. Chairman, I am a former land baroness. I am no longer in the land baroness category. So I do have a kind of an on-the-ground running sense of what it's like for new young people to rent and not be aware of everything. My concern is that this is a sentence that informs them. My question, therefore, is, isn't this more of an education issue than a legislative issue?
It's potentially a education issue, but this is actually the third time this bill's been being brought up, and it doesn't seem like the education piece is getting out there. So that's why I felt the need to bring it up in a bill again.
Thank you.
All set. Okay. Representative Greason.
Thank you, Mr. Chairman, and thank you, Mr. Janigan. I guess what I'm want to make sure is all that is you are seeking in this legislation is a statement in the lease agreement that the lessee would just acknowledge something similar to no pets on the property, and if you have a pet in violation, you're acknowledging you're not going to have a pet, or no smoking on the premises, acknowledging that. And then the next line item might be my homeowner's policy does not cover your personal possession, so I recommend if you want coverage, you would get your own insurance policy. Is that it? And there's no cost, no cost to the landlord, no cost to the tenant.
There's no cost to the landlord. Of course, there's a cost to the tenant if they want to get rent. Oh, there's no cost.
I understand that, but no cost. No cost. This legislation does not impose a cost on either the tenant or the landlord. Just to at least say, do you understand? Boom.
Exactly. Yes. Yeah.
Okay. Representative Burrows.
Thank you, and thank you for taking my question. I'm just trying to understand. I'll give you a scenario to see if this bill would impact it. Let's say that somebody's belongings were, there was a flood and the person's belongings were, totally destroyed because of the flood, but the flood was the result of a negligence on the part of the landlord. Does this bill impact them being responsible for that property in any way?
Whoa.
Well, not being a lawyer, that'd be a tough one for me to answer. However, I'm trying to imagine that scenario because I am a landlord. I think negligence is one of those things where negligence doesn't protect you from anything. So if I'm a negligent landlord not cleaning snow and ice away and somebody slips and falls, then this tenant didn't explicitly say they were responsible for the ice and snow, then I could be responsible through a court action. So I don't see where this gets rid of negligence as an issue. I'm not sure any law ever gets rid of negligence, but I'm not a lawyer. I don't know if there's a lawyer in the group that could answer that, but I don't think that would stop.
Follow up, please.
Further question, may inquire.
Yeah. Do you think then that this law might somehow communicate to tenants that the landlord was off the hook for any kind of responsibility in these kinds of scenarios?
No, I don't think so. This is very specific. We're talking about renters' insurance for their belongings. I think it's very clear. I don't think that would be an issue.
Thank you.
Okay, thank you. Representative Bartlett.
Thank you very much, Mr. Chair. I had 35 years in insurance. Negligence is roughly equivalent to liability. So if a landlord, how do I make this a question? Would you believe that if a landlord is, as representative you gave for an example, was negligent in clearing off snow and someone's injured, then their policy would respond to that type of an injury. However, if there are many other kinds of things that insurance covers that would never be covered under the property owner's insurance. So that's why this notification would really help renters, because in all my years of insurance, there are so many renters that have no idea that they have no coverage for their belongings or their additional living expense if they were actually out of the property. That's all. Thanks very much for bringing this bill again.
Thank you.
Okay, so is that the kid's voice? Is that behind you, Chrissy, or
no?
Here? Okay, so they're gone. Okay, great. All right, I see no more. Oh, I do have another hand. Here we go. Representative Ham. May inquire.
Yes, thank you, Mr. Chair. I am a landlord, and reading this, wearing that hat, it really does sound, I think there needs to be some clarification or added language, because it says the tenant belongings from loss or damage. And that loss of damage could be my fault, or it could be my furnace that malfunctioned, or it could be my roof that leaked, that caused the loss of your belongings. And I know and have experienced that in the past. I mean, I would like this as a landlord, but from the tenant's perspective, it could be interpreted by somebody that, okay, my furnace went, my roof leaked, all your belongings got ruined, and I don't have to pay. So would you believe I suggest there might be need for a few more words in here to make that clear?
Yeah, I mean, I'm open to additional language. However, some of the, I'm just thinking about what you just said. I mean, if the roof leaks or the furnace, I mean, blows up, or, you know, something in a way that damages things, those are, I mean, unless we're back to negligence, where the landlord would be responsible for negligence. But if these things just happen, that's not necessarily that's not the landlord's fault. If it's, and if I've been servicing a furnace, let's say I service any oil burning furnace every year. If something goes majorly wrong that causes damage, I mean, what else could I have done with that? I'm calling the service guy every year. He's servicing it. However, if I'm never servicing the furnace, and you know, oil furnaces should be serviced somewhere in that. I mean, I do it every year, but somewhere in that time frame. If you just never do it and you're negligent and it blows up and causes problems, that negligence then is a wholly different topic. I think, you know, specifically here, I think this does cover it. But as I said, I'm open to hearing additional thoughts on language.
Okay, thank you. Representative Van Houten, you have another question?
I do, thank you. While I'm absolutely sympathetic to this as both an educator and as a landlord who's rented to young people with their first rental possibility, I just don't know. Okay, if I were still a landlord today and I did not include this clause under the legislation that you proposed, would there be any ramifications for me?
I haven't, it's a good question. I haven't put any penalty in the bill. I mean, as it's written, there is no penalty. And partly because my goal isn't here to penalize landlords, it's to bring awareness. I mean, once a bill like this, if this bill passes, granted, the landlords associations are going to begin putting out the word that, you know, make sure that you have this in there. But, you know, as the bill is written, there's no penalty for a landlord.
Thank you very much.
Okay, well, that's an interesting question, right? That circles the opposite. Is that if you don't put it in, does that mean you're liable now because you didn't put it in the contract, into the lease? With that, could someone then, the tenant, then sue you because you didn't put it in? But I don't know. Again, we'll have to ask a lawyer, or people who are experts on that subject. Okay, Representative McCleary has a question.
One of the days we'll get that right. Representative Janigan, I guess. Here I am getting my name not pronounced right, and I'm doing the same thing. I apologize. Is there not a standard tenant form in New Hampshire? A standard form that a landlord would use? I see Christie saying there isn't. I would have thought there'd be a standard form that you could put this in, but I guess I got my answer.
Well, I mean, there's different forms out there. There's no absolute standard that every landlord uses, but there are forms that people can pull from various places. And my guess is, if a lawyer writes it up or somebody does have a standard form, it probably has this in it. But you know, the landlords that aren't using standard forms, and there's plenty of them, you know, then they wouldn't, the potential tenant wouldn't be aware of it.
Okay, thank you. So I have just promoted Rick Blaze up to a panelist, and so that he can testify. Thank you very much, Representative Jenigan.
Good afternoon again, everybody. Again, my name is Rick Blaze. It was on earlier today. I figured out the system. It works well. Basically, I ran a landlord association for a couple of decades. We got over 1,000 members in it throughout the state of New Hampshire here. And there's over tens of thousands of landlords. And the bill's good intentions. I do this with every tenant every time I lease an apartment. And you're trying to legislate common sense here. You know, education is the big thing. I think what you're trying to do, Janigan, you're trying to do is educate the landlord to notify the tenant. Legislation is a dangerous and slippery slope here. There is liability for the landlord should something happen and that wasn't in their lease. Now the tenant can come back and say, you never told me, and now I'm in a lawsuit situation. I'm going to settle just so I don't have to go to court, which might cost me $10,000 or $15,000. Again, in an affordable housing situation, I wear also an affordable housing hat as a president on the board of The Way Home. I just see this as more of a reach. We should be reaching out to people, not legislating to them when it comes to this matter. And if you put some type of, damages in there or penalty in there, now you got a whole war happening from affordable housing. Everybody's going to come out screaming. I just look at it as the intention of the bill. I see the merits of it, but I don't think it should be a legislation issue. I just think I do a good job. I still, even though I'm retired from the Landlord Association, I still hold meetings where I have 40 or 50 landlords every other month come into classes. I'm doing one for NeighborWorks in Manchester here on Saturday. And again, I just try to bring common sense to how do you run a business as a landlord, large or small. And I think if anything, that's where the energy should be put, not so much in a legislation like this. But I appreciate all you guys do and the intent here. Thank you.
Okay, thank you. Does anybody have a question for Mr. Blaze? And I guess we're all done. All right. So on the blue sheet, I have Nicole Forty, who's a member of the public and supports the bill. Robert Best, member of the public, supporting the bill. Paul Parisi, who is the New Hampshire State Fire Marshal's Office, supports the bill. Eric Rathman, who's a member of the public, supports the bill. And Josh Yokola is the state rep, Representative Yokola, is opposed to the bill. And Representative Rebecca McWilliams is also opposed to the bill. And with that, and I see no more hands up, we will end the public hearing on House Bill 473. And for the members, before you all leave us, whether you were here at the beginning of the meeting or not, that I will be scheduling coming forward the remaining we have 4 days. Won't take care of all the bills, but it'll certainly make a big cut in it. So next week, February 2nd and February 3rd, Tuesday and Wednesday. And then the following week, February 9th and February 10th. And we will be having our public hearings, and that I would hope on February 3rd that we can take care of those 2 early bills that we have. So if you have any comments or anything like that, please feel free to contact me. And Representative Herbert, you have a question? Chris, did you intentionally raise your hand or did you not mean to do that? Oh, yeah, there you go.
I keep waiting for you to do it for me, I think is what's going on. But exec, did I hear you correctly that we're going to do, you're going to try Thursday to do some execs?
Wednesday, February 3rd.
Wednesday, February 3rd.
Yeah, that I would like to try. I would like to try to exec those 2 early bills that we have.
Okay, thank you.
And all right, now I will lower your hand, Chris. that I'm willing to do for you. Turning your mic on and off. I'm trying to hold on that. Okay, is anybody else has anything else they want to share? Otherwise, we will see you all again next week. And I think this worked out well and we had a good day.
Good job.
Okay. Take care, everybody. Bye-bye.